Hearing.
No, madam. They have not yet been.
Lordship,
Oh, madam. Okay.
How you have to file an application? Paper book has been filed.
No, madam. They have not yet been filed, madam.
So you have to come with a connected application. Na?
Yes, madam. Scan be filed.
That is what I said. Have you served?
Madam, I am serving the post. Madam, actually, this is against madam. My regularization was madam cancelled. So I need the impute judgment.
So when was the order passed?
Madam, on December 19 December.
This circuit.
Yes, madam.
Lordship, may I be permitted to mention one matter? Lordship,
Without you complete service, otherwise you cannot.
Lordship, may I be permitted? Lordship, one mandamus appeal has been filed on Friday, Lordship. Kindly be taken tomorrow. Can applications are also filed with the matter?
It has already been directed. You mentioned.
Lordship,
Why you are unnecessary?
Lordship, there is an urgency, Lordship.
Are we told you? You only said Tuesday. So today is Monday.
Lordship,
Why you are worried?
if it is not listed,
You would teacher matter.
Lordship,
one sawmill, the
Lordship, may I leave to mention?
Just a
May I-
moment, sir. We will come back to you.
Lordship.
appellant has a sawmill and the operation of sawmill has been suspended by the forest authorities. And
Have you completed service?
Lordship, during the course of the day,
Without service, we will
Lordship.
not take up.
Yes.
কালকে দিয়ে দিও।
One correction of the order.
Correction, which order?
Last 15 December.
What correction?
The last line of the order, the tribunal order of the tribunal is modified, order dated, that is the correction, order dated.
The tribunal's order date has been wrongly
Date.
noted. To be mentioned tomorrow. Tell your other side.
Madam, Mr. Thor is appearing online.
Lordship, I have an extreme urgent appeal, Lordship, with a stay petition. So I crave leave to move it without certified copy. My fellow brother is in court. He will file
When was the order
copy of the
passed?
order passed on 19th, Lordship.
The server copy is there. Have you got?
Yes, with server copy, I'm moving this.
So what is the
With server
urgency?
copy. Urgency is this, Lordship, that in spite of this Honorable Court's order passed by Honorable Justice Shobhoshachi Bhattacharya in regards to the petitioner one-time settlement proposal to the bank to consider it in accordance with law, without considering this, they have fixed the date for auction on 30th of this month. So challenging that auction, Lordship, I move before the Honorable Single Bench, and the Single Bench dismiss the matter.
Where is you? Have you completed service?
Why not we have?
Lordship, I will complete in course of day, Lordship. Today, I will
Yes.
sign.
দিয়ে দিও কালকে সুরজিৎ ওইটা দিয়ে নাও ওইটাও দিয়ে লিভ গ্রান্টেড লিভ গ্রান্টেড ইউ সার্ভ ইট উইল অ্যাপিয়ার
Lordship, may I be permitted to mention with regard to item number 11? Lordship, may I be permitted to mention with regard to item number 11 of today's list, your Lordship?
Yes.
Lordship, it is an order 43. I've come up against a rejection of an ad interim injunction. Your Lordship, your Lordship, it is appearing since Tuesday, your Lordship. Lordship, may
What can
very
be done?
kindly, Lordship, very kindly takes it up today or tomorrow, your Lordship. In the event,
Let
your
us
Lordship, Lordship,
Let us see
Lordship.
how. Yes.
Grateful, my Lord, grateful.
Item number 1. For that,
How many days delay?
no, there is a delay, well, 83 days delay.
Eh?
84 days delay as per.
Have you served?
Yes, not.
Who is your other side? Eh? Mr. You are appearing?
I have not appointed.
Then who is appearing?
No. According to our cause list, official cause list, there is no endorsement till today.
Then when did you serve? You have not served also.
Well, Friday,
Friday you have served where?
no, office of Talanet.
Then come tomorrow.
Well, delay, my lord, I have served.
Sir, he has to be engaged. Friday you have served, today it has appeared. Maybe allotment has not been made.
Maybe discretion court whether.
Huh?
It's a discretion, Lordship, whether I will appoint it or not. One court can appoint another office.
কিন্তু সময় নেই মিনিচুর কে পাঠাবে আমরা জানি If tomorrow nobody appears, we will consider not yet 48 hours notice. Not today করে রাখ
Number 2, Madam for the state. I'm for the applicant, sir. I have asked the customer, it was delivered.
Application is Cranford.
Cranford, I just finished.
Yes, Mr. Pud.
Well, first I submit that my chair was turned down on 29th of July 2025. Page 14 is the order, madam. This was turned down, my prayer, madam. But I paying my bill, but due to my I am in
It
custody.
was also turned down on
Yes,
April
madam, first
31st.
time, first time.
How long you are in custody?
5 years, 5 months, madam.
5 years, 5 months.
Yes.
That is prior to trial.
Yes,
No,
madam.
no.
From the date of arrest.
From the date of arrest
From
till
the
5
date
years,
of
5 months.
Yes, madam, till today, madam.
How much imprisonment?
20 years, madam. 20 years.
What is the allegation
My
against?
allegation under section 6 of the POS. My pinpoints, submission.
Item number 3.
Three, I appear on behalf of the petition.
আচ্ছা প্রসিডিং শেষ হয়ে গেল। WPCT.
Yes, but
Wait, let us get the file. রোববার ধার্মিক উৎসব জানটান আমি দেখি সব জায়গায়।
না, জিজ্ঞাসা করছি পুরোহিত কেমন আছেন?
ওখানে দেখলাম লোকের থেকে ভালো বিয়ে করে
ভালো মন্দ করে উঠছে। আচ্ছা,
taking substitution of the petition.
Substitution.
Substitution.
Sir, let him finish, sir. Sir, what is this? Please take your seat. Please take your seat.
Page 53, my lord, is the order passed by this division bench, my lord.
53.
Page 53 of my canon. Lord, 53 onwards is the order. Page 55 is the operative portion.
What was the, let us give us 2 minutes time.
Fine.
So what was the 7th respondent order? First, it was referred to the railway board.
Railway board, my lord.
Then in the subsequent matter, it was said that authority would be the respondent number 7.
7.
Division
Then, my
that
lord,
we
and
mentioned.
an order was passed that a recent order shall be passed from 6th respondent by the 6th respondent.
No. First point 7.1 part impugned decision of the 7th respondent shall be kept in abeyance. What was that decision?
Lord, no decision was taken.
7th respondent.
Lord, that was inadvertently written as 7th respondent. That will be the 6th respondent.
Is not the 6th respondent. Divisional railway manager is the 6th. He is the divisional financial Northeast Frontier Railway. Anyway, what do you want now?
Now, my lord, I want substitution as because I want to file a contempt application.
Substitution in a proceeding which has concluded.
But, my lord,
Was the provision of law.
Lord, but this order has not been complied with. Lord, this order passed by our division bench has not been complied with, my lord.
Who are you now? You are the son of
I am
the
the son of the petitioner, my lord.
So when did Pratima expire? When did
Prati-
your mother expire?
Lord, mother expired on 5/12/2024. My lord, the death certificate is at page 58.
5/12/2024.
24, my lord.
And the order was passed when?
On 11/12/2023.
11/12/2023.
Yes, my lord.
Then time given was for 6 weeks.
No, that this order.
6 weeks, what did you do?
What?
Order was 11 December.
My lord.
You died after that expiry of 6 weeks.
I died after the expiry of 6 weeks, my lord.
Then you should have taken immediate steps, no?
Lord, Lord, I'm aware of such, my lord, but
Then show us the proposition of law that in a proceeding which has culminated, a person can be substituted for reviving the claim. Had it been a case that the proceeding.
There is this whole. So for filing contempt proceedings, but person did not survive. Any year can file the contempt case.
ও তো এখানে সাবস্টিটিউটেড হতে চাইছে।
They could apply for delivery. Regarding contempt proceedings, you file.
You file.
That's a separate right.
Proceeding proceeding is an implementation. Proceeding for contempt is for non-compliance of the order.
my lord.
So in your contempt application, you say those things and.
For
you
example,
file.
in execution of a decree, if the degree holder dies
Still it
and
continues.
the decree has not been complied with, the heirs can file execution of the decree.
There is no but in an execution proceeding under that is also under civil procedure code.
And this is under Contempt of Courts Act.
In contempt of courts act, you have to, because now your contempt will be time barred also.
Time barred.
Because 5th December 2020, order was 2023 December. 6 weeks from that takes you to say February 2024. So February 2025 is the date of expiry of that order.
Because of expiry of my mother, my lord, I could not.
That you have to take.
Pilot fresh petition to implement.
May I make an innocuous claim, my lord? Lord, let the can to be disposed of, my lord, I will not place the, my lord, let the can to be disposed of and my lord, liberty may be given for me to prefer a contempt application, my lord.
How can we give you that liberty when your contempt is time barred that the contempt court will consider? Or we cannot advise you,
Well.
or you have to take steps for the implementation of this order because rightly your mother has expired. File a fresh writ petition. Is it not? In a civil proceeding, proceeding has concluded. You are right. You are the deceased son. So the benefit which was given to your mother, it will accrue to you also ultimately. But in the closed proceeding, how can we allow an application for substitution? You withdraw, we can say that allowed to be withdrawn with liberty to take appropriate steps
To implement the order.
With liberty to take appropriate steps. No, for implementation of the order.
No, to take step for in accordance with law.
সেটা বলতে পারো।
For the necessary.
We will say that we dismissed as withdrawn with liberty to take appropriate steps before the competent authority, if so advised and in accordance.
Grateful. Lord passes that.
Only one submission, Your Lordship. Honorable Court's order had already been complied. Order was
Complied.
passed in June 2024.
No, my lord, that order has not been complied with.
That
No,
is the
that
another.
recent order passed.
Yes, Lordship. Over my information.
No, if he's agreed by the order, he will challenge after.
Yes, yes, Lord. He also can challenge the in the face request.
Yes.
But may I just indicate one thing, my lord? My lord, as my learned senior has submitted as such, my lord, page 56 is the order, my lord, which says that a reasoned order shall be passed by sixth respondent, the divisional railway manager, Northeastern Frontier Railway, Kathiar, Bihar, in the matter within 6 weeks, from the date of communication of this order, after giving an opportunity to the petitioner to place all relevant documents. Now, my lord, when did the hearing take place?
That is
My lord, no opportunity was given to
No,
me.
very
to
well.
place all
For
the
that, you
relevant
can
documents.
challenge in a
That
press
is
writ
the
application.
case data.
No, if you have that copy of the order, you can communicate to your learned friend.
Communicated as per my instructions already communicated to him.
Uh,
No, he
give
does
a
not have
copy
that
now.
I
copy.
have sent the hand over the copy today.
Yes, give the
Yes,
copy to
I-
him so that
Yes, Lordship. I'll soft copy my.
in course of hearing, এই বলে দিতো, the learned advocate appearing for the petitioner prays for submits up, comma, upon instruction.
Substitution is not maintainable.
এটা
However,
বলে দিই।
because the matter is already disposed. However, the people
তাহলে
only
এই substitution discuss করতে হবে।
because
At
the
lines high.
petition is disposed and the writ petitioner dies after the disposal of this matter. However, as it is given for non-implementation, you can take steps in accordance with law.
Where have you stated in your substitution application when your Pratima died?
But para 14, that is on page
14.
14.
You are the sole heir.
No, my lord, there are two stuff and one dot.
Then who has filed this application?
But
All the heirs.
the years. But para 20, page 22, para 14 minute.
Page 22.
Page 22 of my application, my lord, para 14.
Ashok, the records reveal that a writ petition preferred by one Pratima Sarkar before the learned the writ petition preferred by one's Pratima Sarkar was disposed of by a coordinate bench of this court. By an order dated 11th of December 2023. A writ petition being WPCT 4 of 2019, records reveal, was disposed of by an order dated passed by a coordinate bench of this court. What is your name, sir?
But Mayank Roy.
In connection with the said writ petition, an application for substitution. What your substitution? You have said where?
My lord, I've said.
An application being Can 2 of 2025 has been preferred, praying for substitution of the legal heirs of Pratima Sarkar, who had expired on
5/12/2024.
5th of December 2020.
2024.
2024. He further submits that by the order dated 11 December 2023, the coordinate bench of this court directed inter alia directed the divisional railway manager, Northeast Frontier Railway, Katihar, Bihar, to take a decision as to whether the husband of Pratima Sarkar, namely, late Birendra Kumar Sarkar, had superannuated in the statutes of page 55 capital E, capital S, capital M, grade 1 or grade 2, within a period of 6 weeks from the date of publication of the order. In spite of due communication of the said order, in spite of due communication, the respondents have not complied with the said order till date. Such contention has, however, been disputed by Mr.
Ajay Singhania. Ajay Kumar Singhania.
Will we record that you have already passed?
Already passed order, 26/6/2024.
So you can give it in course of this day.
That's it, sir.
Mr. Singhania, learned advocate, appearing for the respondents, however, submits that the order dated 11 December 2023, passed in WPCT
4 of 2029.
4 of 2029. And
2019.
no, sorry, 2009 verses. আগে কত বলেছিলাম কি লিখলে has already
Hmm.
2019 has already been passed
June
and
2024.
passed in the month of June 2024, and the order was also communicated. However, he however communicated was already passed and communicated. Mr. Singhania submits that a copy of the said order would be handed over to Mr. Roy in course of this day. In the present case, the writ petition being WPCT 4 of 2019 has already been disposed of on 11th December, has already been disposed of on 11 December 2023. In a disposed of writ petition, the present substitution, the present application for substitution being can such and such in a disposed of writ petition is not maintainable. In view thereof, the application being can such and such is dismissed with liberty to the applicants hearing. Word applicant or applicants? Where have you, in the cost title, where have you given?
এই তো এই তিনজন
Your, no, no, applicants এখানে cost title ই দেয়নি, your cost title is defective, sir.
নামটা বলে দিতে হবে তিনজনের নাম, নইলে পরে আবার কনফিউশন হয়ে যাবে।
Application has been preferred jointly or
Page 8 of my application.
page 8. It's not the procedure. আচ্ছা ঠিক আছে, কি লিখলে? With liberty
The application we can do 2025.
is dismissed with liberty to the applicants to with liberty to the applicants to take appropriate steps before the competent forum, comma, if so advised and in accordance with law. Yes. যেখানে যে কোনো ইউনিভার্সিটি আছে সব জায়গায় ঘোরা
যেরকম আন্দোলনের জন্য আন্দোলনে একটা
Millard, your Millard's queries was regarding my, this representation Millard. In my stay
Sir, please
application.
tell us the facts first.
Millard,
What happened actually?
that my husband was in the field, Millard, and there was unkept this unattended high tension electric wire, Millard, nearby my house, Millard. And when my husband was there, my Millard, so he got electrocution, Millard, and as a result, he died, Millard. In my stay application, Millard, Page number,
So the
32
widow approached the court.
yes, my lord.
Widow
widow
approached
below.
the court after filing a representation on 15 July.
Yes, my lord.
Now that was not considered.
Not heard, my lord.
So you came to read court.
Read code, my lord.
So read court said that it is a triable issue. Go
Yes.
before the appropriate forum.
Yes,
Read
ma'am.
petition not maintainable.
Yes, my lord.
So what do you have to? What is the wrong in the order according to you?
But this is a public law, my lord. There are catena judgment of the
Ah,
Supreme Court
being
as well as the-
Leelapati Behera, have you brought the judgment? Leelavati Behera, have you brought the judgment?
Not today.
So where it has said, in the order where it is said that writ petition is not maintainable, has it been said?
My lord. My lord, order, page number 2 of order.
Hmm.
The married, my lord.
Yes.
The petitioner, on the basis of the allegation made in the writ petition, claims compensation. This is a triable issue. To assess the correct figure of the compensation, if any, payable to the petitioner, a proper trial is required to take place for which the constitutional court is in exercise of its power under 226 of the Constitution of India is not a forum.
State functions, there are কিছু এত compensation.
Electricity distribution company.
So why didn't you say that upon considering the representation? You could have told him that there was no negligence on our
Yes,
part,
sir.
you are not entitled to compensation.
No, whether there is any, he is entitled to get any compensation or not,
Hmm.
that has to be determined after taking evidence.
No, did you conduct any inquiry after this accident?
No.
From
What
your side
happened?
inquiry?
What happened to the criminal case?
But it is still pending, my lord.
Still pending.
My lord.
My lord,
So you are a statutory authority, you will not take a decision on a widow's representation, that go to civil court, he will roam about there for 10 years. The fundamental right violation. You are almighty, you see that I will keep quiet, let him run from pillar to post. Ultimate writ petition, dismiss, very good, well done. Now go to civil court. By the time civil court will pass the order for compensation, she will also die. See your attitude, whether it was uninsulated, wired or not, it is a fact to be said by you. Did you conduct any inquiry upon receipt of the
See whether in this type of cases, how much compensation can be granted? What is the scheme? So many things are there for you.
Considered within a particular period after inquiry and pass a reasoned order.
Yes, what report you have brought?
well, as per police has initiated FIR, my lord, charge sheet submitted. After submission of charge sheet, my lord, police has made a further investigation prior, my lord, that has been allowed. And the accused is absconded. So warrant has been issued.
Who is the accused?
The station manager against whom the
The-
allegation has been made out.
So there was a final report, then Nadaji petition, then fresh investigation.
That I don't know, my lord. As per the
Yes,
available
what?
documents,
Hmm.
police has made a prayer for further investigation and that one has been allowed.
Oh, after filing the charge
Yes,
sheet?
If my lord goes to page 10 onwards of the report.
Page 10.
Yes. On the top. On 1st of August 2025, the charge was issued.
Yes, yes, then warrant, no, someone was issued.
Someone was issued, my lord. And thereafter, my lord, on the date is
Now, what did you find in the
13th of
prima
August.
facie page?
Cognizance taken.
Now, they
So-
after received a prayer for passing this for continuing further investigation.
Yes.
Now the question is prima facie, there are materials, so why don't you take into consideration the compensation aspect? Prima facie, there are certain materials. So why don't you, this is a civil law, civil right. You see, undisputedly the person has suffered an unnatural death. So prima facie, there are so many materials, investigations. So why didn't you take into consideration that compensation issue?
Unofficially, my lord, already they have set up a board, inquiry done, and they have declared that their officer is not involved in any negligence.
No, it is you're from the state government side.
No, my lord.
You are for the state government.
Yes, my lord.
He is from the authority.
Yes, my lord.
So you see, this compensation aspect is to be looked by you. Why are you not taking steps?
নোটিস করেনি ওরা উল্টে স্ট্যান্ড নিচ্ছে যে আমাদের দোষ নয় অথরিটির দোষ নয় ওই ছেলেটার দোষ ওর ঘাট থেকে পেলে
তাহলে ওরা এটা বাড়িয়ে যাচ্ছে এখানে ফোরাম থেকে ইলেকট্রিসিটি দেখেছি সেটা তো কোনো কোর্ট নেই
এখানে তো প্রাইমা ফেসি চার্জশিট হওয়ার পরে ফার্দার ইনভেস্টিগেশন হয়েছে যে ওদের পার্সন হি ইজ অ্যাবসকন্ড প্রাইমা ফেসি এভিডেন্স আছে যে দেয়ার হ্যাজ বিন
There's some warrant against it. That
But
has not
someone
been
issued.
allowed. That has not been allowed.
কোথায় হয়
Someone. I have paid for issuance of WA.
From our end, my lord, we have taken the initiative.
and they have set up a parallel inquiry you are saying
My lord, when the matter was taken before the Reed Court, my lord, single bench, my lord, before the single bench, this was the submission. made. So from that, I came to know that there was a
Yes, what is your instruction?
later affidavit we call for.
Oh. Later affidavit, it will be hard after say 5 years. By that time the widow will. What is your attitude, sir? Ask your director to be present before us tomorrow. Why payment, why compensation shall not be paid? You are taking it in a slipshod manner, huh? You are governmental authorities. Huh? Go and say I will file. Either you settle and pay compensation, otherwise we know how to deal with your officials. Police said investigation prima facie material, go to civil court. A person will go to civil court for determination. Ultimately, if the conviction, ultimately, if it is held that goes in his favor, then under victim compensation scheme, he is entitled to compensation. Yes, what is your instruction? Have you spoken with your officer, sir? তো কিছু বলবে না।
তো এখন ডিটেলস না পেলে তো আমরা ডিসাইড করতে পারবো না।
Way of an affidavit, we are making appropriate observation, asking him to file a affidavit of compliance by the time.
Not compliance, Lordship, if you report in the form of.
It's governmental authority, instrumentality of the state. This is the way you deal with issues. One line said, I am not in.
Whether there is any negligence on the part of the authority, that has to be determined after the evidence is taken.
No, from
Person
your
has
side
died.
inquiry, your departmental inquiry, maybe court will do its function. What you have done to
You
see,
could have initiated the
Whether it is
proceeding.
Departmental inquiry or not, I will take
this
instruction.
is the public interest, a person has lost his life.
The present appeal has been preferred. Challenging an order dated. Challenging an order dated
1st September 2020.
1st September 2025, passed by the learned single judge in a writ petition being WP 1727 of 2025. Inter alia, praying for issuance of necessary direction upon the respondents, particularly the West Bengal State Electricity Distribution Competent Company Limited, bracketed WBACDCL, to forthwith pay compensation of rupees 5 lakhs to the petitioner for the death of her husband due to gross negligence on the part of the authorities. Mr.
Pratap Khati, KHATI.
Akil and advocate appearing for the.
Milord, 5 lakhs, 50 lakhs, Milord.
Sorry, 50 lakhs, 50 lakhs করে দিন। আচ্ছা, Mr. Learned advocate appearing for the appellant submits. What he used to do, your husband?
He's a labor, Milord. Labor, Milord.
Have you stated anywhere?
Yes, Milord.
Where have you stated?
Carpenter.
No, madam. Not stated.
Where have you stated?
Not stated.
That the submits that the appellant's husband, comma, namely Bir Bahadur Rai, RAI, was the sole earning member of the family. Stop. He expired due to electrocution on 11th March 2025 near his house at Upper Suruk, under the jurisdiction of Jaldhaka Police Station, District Kalimpong. Kalimpong. Stop. Immediately, a complaint to that effect was lodged by the appellant, and the same was registered as, what is the case number? And the same was registered as FIR number 425 dated 11th March 2025 under sections 106 stroke 3 bracket 5 of BNS. কোন সালের ওটা BNS such and such. আচ্ছা, died due to electrocution বলেছো না? As would be evident from the postmortem report. তারপরে ওটা যেটা দিয়েছো. The case was registered. But no steps have been taken by the authorities thereafter. And as a thereafter, stop. He further submits that the authorities, that there was gross negligence on the part of the WBECDL authority, in as much as a 440-volt electric wire was left hanging loosely between two poles with insufficient clearance from the ground in the concerned area. Stop. The incident which occurred was neither a natural calamity, neither a result of natural calamity, nor an act of God. But the unfortunate incident occurred due to the reckless and grossly negligent conduct of the WBCDL authorities who failed to maintain the basic safety norms, resulting in the exposure of a live high tension wire in a residential zone. He further submits that in terms of the provisions of Protection of Human Rights, Human Rights Act, 1993, and international covenants, the appellant is entitled to compensation for violation of the basic human rights. Stop. In support of such contention, he has placed reliance upon the definition of quote unquote human rights in section 2 of the Act. In support of such contention, কি লিখেছে? No, he has placed reliance upon Section 2 of the Act, in which, quote unquote, human rights are defined as the rights relating to life, liberty, equality, and dignity of the individual, guaranteed by the Constitution. Stop. Such argument as urged was glossed over by the learned single judge, and the writ petition was dismissed. Such infirmity warrants interference of this court. Reliance has also been placed upon the judgment delivered in the case of Nilavati Behera, alias Lolita Behera, versus State of Odisha and others, reported in 1993, Volume 2 SCC 746. একটু চেক করে নিও তো না সাইটেশনটা। আচ্ছা, মিস্টার
Kumar Santanu.
Mr. Shantanu, learned advocate appearing for the state respondents, submits that the complaint lodged by the appellant was registered as FIR, and upon investigation a charge sheet was submitted.
My lord, once again, my lord, I would request the court to look into the charge sheet page 4.
Yes.
My lord, from bottom, my lord, second last paragraphs. During investigation, Sagar Basu, the station manager, Jalpaiguri, complied notice under section 94 BNSL and produced a detailed report bearing memo numbers such as such. I also sealed the document under proper seizure list under audio video record. Thereafter, my lord, page 6. During investigation, I also collected a report of departmental inquiry of Sagar Basu, station manager. So there was an inquiry report.
কি লিখলে?
Shantanu. Submits that the complaint lodged by the appellant was registered as FIR, and upon investigation,
A charge sheet was submitted. A charge sheet was submitted. Thereafter, charge sheet was submitted on 1st August 2020. 1st August 2025. When the investigating officer,
No, my lord. Subject to correction, my lord, 29th of July 2025.
No, placed, you have submitted charge sheet in court.
29th July.
The charge sheet dated is 29, but cognizance was.
Cognizant 1/8.
1/8.
ও কি লিখলে? চার্জ শিট ওয়াজ সাবমিটেড বলেছো তো? চার্জ শিট was charge sheet dated 29 July 2025 was submitted. Subsequent thereto, the investigating officer prayed for issuance of necessary direction for continuing further investigation. Upon consideration, such prayer was allowed by an order dated
My lord,
3rd August
21st of August 2025.
21st,
It's followed
page 11.
12. Page 12, my lord, order number 9.
21st August 2029. Stop. And summons was also issued to the accused, namely Sagar Basu, who happens to be an employee of WBCACD.
Second, madam.
Acha, however, the said incumbent has not responded to such suspension. Responded has not entered, appeared.
He appeared
Acha, ঠিক আছে, just stop. Next paragraph.
Anirban
Banerjee.
Banerjee.
Mr. Banerjee, something has to be done. Mr. Banerjee, learned advocate appearing for WBECDL, however, denies the contention of Mr. Khaki and submits that there was no negligence on the part of the WBACDCL authorities and that the writ petition has been rightly dismissed since an issue of investigation since compensation is a trial issue, is a triable issue, and the same cannot be assessed by a constitutional court in exercise of constitutional court, and in view thereof, the writ petition was rightly dismissed with an observation that the same would not preclude the petitioner to institute appropriate proceeding before the appropriate forum. Stop. Prima facie, in our opinion, the observation of the learned single judge that the appellant would be at liberty to approach the appropriate court for assessment of compensation, appropriate authorities for absolute appropriate. Prima facie, in our opinion, the observation of the prime minister, the prima facie, in our opinion, the writ petition, prima facie, in our opinion, the observation in the impugned order that the appellant would be at liberty to approach the appropriate forum, meaning thereby the competent court for damages is not acceptable, since in the facts of the case, public functionaries are involved and the matter relates to violation of fundamental right. The mandate of Article 21 should be complied with the mulct, MULCT, its violators in the payment of monetary compensation. Stop. Records further reveal that there had been next paragraph. A copy of the charge sheet as placed before us reveal that a disciplinary proceeding was initiated by the WBCDL authorities
Departmental inquiry. No, Lordship, disciplinary proceeding and departmental inquiry was selected.
sorry, oh,
Page 6.
এরকম কি লিখলে?
Because
আহ,
you will get copy of charge sheet, that will,
No, no.
copy of the charge sheet, that will-
No, no, last কি লিখলে is not acceptable to multi violators in the present of monetary compensation. Stop further. A perusal of the chart sheet further reveals. A perusal in the chart sheet. In the chart sheet also it has inter alia been observed that quote unquote এটা বসিয়ে দেবে। Page 6. This is a Xerox copy, Mr.
Yes, Father.
Do we have to return it to you?
No, it has been certified to a true copy, madam.
Oh,
That is
then
for the court, madam. I have the copy.
you have a copy?
Yes.
Then we can keep it.
Yes.
Stop. In the said conspectus, stop. However, next paragraph. However, the WBACDL authorities have maintained a deceptive silence and have even not considered the representation submitted by the petitioner, by the appellant on
15 July 2025.
15 July 2020. 20. In view thereof, the respondent numbers. No, next one. The next paragraph. The writ petition appears to have been dismissed without even inviting the parties to exchange their affidavits. Expense their in view thereof, no, no, in view there, no explanation is forthcoming as to why in the conspectus of facts detailed herein above, no decision has yet been taken by the WBCDL authorities towards payment of compensation to the appellant. In view thereof, this court directs the respondent numbers to respondent numbers 2 and 3 to file an affidavit in opposition, disclosing their stand. Disclosing their stand. And to satisfy this court as to why necessary direction shall not be issued against them for payment of compensation to the appellant. Stop. The state respondents being the respondent numbers 1, 4, 5 and 6. ওটা 2, 3 and 5 হবে উপরেরটা 2, 3 and 5 হবে 2, 3 and 5 আর এটা হচ্ছে 1, 4, 6 comma represented by Mr. Sanglanid advocate is also directed to file an affidavit in opposition. The affidavit in opposition placing the charge sheet and the orders passed by the learned court
Court of session.
court of session.
Citizen court, sir.
Can I put it in a form of affidavit, a report in the form of affidavit instead of opposition?
No, you give an opposition because you are prima facie in favor of the appellant. You will not.
Opposition হচ্ছে না এপিডেভিট ইন সাপোজ মানে কমপ্লাইং দ্য
তাহলে ওদেরকেও এভিডেভিট বলতে হবে। তাহলে ওদের বলে দিবি এভিডেভিট ইন ফর্ম অফ রিপোর্ট, ওদের বলে দিবি।
এপিডেভিট হ্যাঁ ফর্ম অফ রিপোর্ট
That should be quicker, ma'am. That's why.
আচ্ছা, ওই মিস্টার ওনার নামটা WBC, হ্যাঁ, মিস্টার ব্যানার্জি যেখানে আছে, ওখানে এভিডেভিট না ফাইলে, তাহলে ওটা হু ইজ দি কম্পিটেন্ট অথরিটি মিস্টার ব্যানার্জি? ইন ভিউ, ওইটাতে লিখবো ডিরেক্ট দি, ওই প্যারাটা পড়ো।
Individual of respondent number 235.
In view thereof, this court directs the respondent number 3 to file a report in the form of an affidavit. বলে ওই কি হ্যাঁ, নেক্সট প্যারা দাও।
Satisfy this court as to why
হ্যাঁ।
necessary direction shall not be to take as then
হ্যাঁ।
payment of compensation to the appellant.
Stop. Mr. The representative are also the respondent number. Next para দাও। তো do we officer in charge কি বলবো? Stated.
Both places are very
Officer in
far.
charge কে বলো।
Dhaka is
materials of
north
investigation.
and
আচ্ছা,
Kalimpong
the
is south.
Yes,
respondent
officer in
number-
charge will file a report regarding
the
investigation and
respondent number 6 shall also file a report in the form of an affidavit disclosing the affidavit
about the stages of investigation.
File an affidavit disclosing the orders passed in the pending criminal proceeding and shall also enclose a copy of the charge sheet that has been, and shall also given, and shall also shall file a report in the form of an affidavit enclosing the charge sheet file as well as the orders that has been passed till date in the pending criminal proceeding. Stop. That such affidavits by the respective respondents be filed positively next circuit bench কবে?
Fifth, madam.
No, and the documents collected
And the documents collected.
in course of investigation.
And the documents collected in course of investigation.
That can application for fundamental of duty.
That. Stop. The such the positively by থেকে বলছে fifth থেকে circuit, positively by 12th January 2026. List the matter for further the positive stuff. List the matter for further consideration in the daily supplementary list of this court on 13 January, subject to the convenience of the honorable circuit bench. Stop. আর উপরে লিখে দাও।
Madam, do we need to submit the report to serve a copy of the report to the petitioner?
Yes, you can give
Then,
that.
my lord, he can take he will also need time to file any exception if any.
No,
So
that
first of all, let the report come,
let
let
the
the,
report come.
thereafter necessary
After
direction.
seeing that, if the court finds, if the report, if they, after this order, if they decide that they will take some steps to pay some amount of compensation, then the court will decide. By 13th করে দাও, by 13th করে দাও, তাহলে by appear on 14th করে দাও। 13th, 14th আছে। আর উপরে একটা লিখে দেবে, in connection with the appeal, an application for condonation of delay being such and such has been filed. Stop. Upon hearing the learned advocates appearing for the respective parties and considering the materials on record, comma, we are satisfied with the explanation given towards the delay in filing the present appeal, stop accordingly. Such delay is condoned and the application being such and such is disposed of.
Ridiculous.
এটা তো বলছি এদের কাছে দেওয়া আছে। তবে 5 তারিখ থেকে নেক্সট স্যার কি দেয়?
Yes, ma'am.
তারপর 5 তারিখ থেকে বা 19
No, madam, 60.
60
Thereafter, madam, on 17th, the inauguration, and next activity is in the month of February. 11th February.
সামনে আরেকটা মাত্র এখানে হবে লাস্ট ইয়েটা
হুম। Where is your service?
My lord, we will do it within the course of the day, my lord.
If they are not present, we will not take it up.
My lord, we will do it. We will do it.
You are doing will not do. You have to complete it by tomorrow. Otherwise, this can't be. What is the urgency? I don't. দিয়ে রাখো লিস্টে। Yes, next.
Item number 5.
Yes, Mr.
I'm appearing for the respondent number 2.
Yesterday evening, this matter was handed over to me. From the
no can one
10-1. 10-1 is lordship,
There were 2 read petitions.
3 read petitions. 2 dismiss and peculiarly the third one on same point has been admitted.
Why do you say peculiarly?
Lordship, same point, our 2 read petitions have been dismissed, but third one has been admitted.
Third one has been admitted because the work order has not been issued there.
Order, let us see. You are pressing one order passed in connection with one read
One.
petition, which is pending.
Which
No.
is, no, which has been disposed of now, we have filed
Twice.
an appeal. This is the matter.
To take us to the order impugned.
Lordship, order impugned is, Lordship, at last page 65. 65.
is whether two contradictions, whether work order has been issued or not.
No, what as
This
per
is
her,
the thing.
her submission, she cannot produce the work order, but she says the work order has been issued.
No.
Work order in serial number 2, I am producing it, but regarding the serial.
Yes, please show,
number
please show serial number 1 work order and your notice which you affixed.
Note, Lordship, I am affixing the notice of 21st August, the work order in respect of the serial number 2 issuance to the agency, the status of the work, and the other, these three I am submitting for the Lorships.
As per my instruction, my
And
line
the
is
others
the L1.
are my instructions.
L1.
This is
But-
21/8,
But
21/11.
No, Mr. Ganguly, now the fact scenario has changed. Now, suppose today if we pass an order in your favor, we will be affecting, purportedly, we will be affecting persons who have been allegedly given the work order. What
third party
will
right
come
has
to
been created.
third party right, and we will be, in order to, suppose you are praying for, you will be praying for a stay, because if we pass any sort of interim protection in your favor, it will be affecting two persons, so they are not on record before us.
Lordship, then kindly appreciate one thing. She is giving work order of one word.
We can do this much, we can record your submission, keep the points open to be considered, and we can ask them to file evidence.
and result subject to the result of the mandate. As because Lordship, Lordship, one work order she is showing, another she cannot.
Another I do not have. I do not
No,
have.
no, we
has
will
been
record.
So regarding that work, which she cannot show that work order has been issued, that can be stated. Another, on 20th December, I have the videography of all.
Not on that, Mr. Ganguly.
The work has
she
not
is-
been started.
She is a responsible person. She is saying, I don't have that work order, but you record my statement work order issued. What more can we do?
Then our submission is Lordship.
Yes, Lordship, my
Then
submission.
no notice of that sort was put within the.
We will-
Lordship, my submission is only regarding the instruction that I have received from the respondents.
কাজ চালু হয়ে গেছে বলছি, আসলে প্রবলেম আমরা দেখাতে পারছি না, এই কম্পিউটার সেটা তারা কি বলবে? So why have they not handed over to you the work?
Lordship, I have asked for it several times repeatedly that kindly give me the work order status of the serial number 1 and 2. Only regarding the serial number 2, they have handed over the issuance of to the agency and the completion certificate of the photographs. But regarding the serial number 1, they have only given me instruction that it has been initiated.
Pension বিটটা কত টাকা? যদি ওরা তো একটা থেকে যেতে kept pending?
It was kept pending because at that time, as per the instruction which was received from the respondent, that work orders regarding that petition, work order number 3, 4, and 5, were issuance was pending. It was not handed over to the agencies. Result have been published, but the work order has not been issued and not handed over to the agencies.
I see. And in those two cases, work order issued, court held that work order is been issued, so
That's yes, sir.
এই যে এখানে তো বলে দিয়েছে তো পিটিশনের মেয়াদ এই যে ওয়ার্ক অর্ডার হ্যাজ বিন ইস্যুড তবে এটা সাবমিশনই বলেছে কিন্তু প্রডিউস করেছিল কিন্তু সেটা সো অন ইওর সাবমিশন দিস order was recorded that the work order has been issued.
But department have only handed over one work order to her.
That is on 15th December
That is
on your submission. At this stage, after the work order has been না যেটা আমাদের কাছে আছে কি ব্যাটারটা এটা আমাদের কাছে রয়েছে সেই সেটাই বলেছে after the work order is issued the court does not accept the petition তাতে কোনো ইলিগ্যালিটি আছে এটাই একটা কথা এই যে 15
work order to issued হয়েছে, that is help you
The legality is the point which I am raising.
that you have not raised before the learned single.
Lordship, it is not, Lordship, to my little understanding, it is.
At the same time, court has denied to exercise discretion on your part.
Lordship.
Why? Because 21st August, according to the court, it is a local work. It was published in the office.
Lordship.
And now, court,
Lordship,
what
Lordship.
court has said, except paragraph 9, that
Lordship.
except everybody, petitioner did not comply with this.
Lordship,
On the basis of this finding and as
it is their
work-
submission, their submission.
and as work order has been issued, so they are saying that, so court said that no purpose will be served. Your argument that it has to be an online submission,
Lordship, it is the rule.
your argument that it will be an online submission, no such notice pertaining to the tender can be published by an offline process.
Lordship,
This argument has not been argued, not touched by the
it has been argued and it is mentioned in the repetition even.
court exercise discretion.
Now,
See,
that's
I-
the reason before the, Lordship, kindly appreciate one thing. If something is illegal, if something is stated to be done in a particular way, can other way be?
Now here you see what is the main problem. Third party right has acted. Otherwise,
Yes, Lordship, in one case.
no. What is before us?
No, before us is two cases.
Yes.
That means two work. Regarding one, they are submitting that work order has been issued.
In the others, did your client participate?
Yes, Lordship.
5, 8 and 9.
Yes, Lordship.
Now, who has been given work order in those two? Which person?
Lordship, regarding this appeal also, appeal only, serial number 1 and 2, 2 I have handed over to your Lordships. Regarding 1, I have been submitting that I do not have the detail.
That you
regarding-
have said, 2 you have handed over means which one?
2 is the paver block 1.
Where is that work order?
Sinod Lama.
এটাই তো মাথার problem.
নোটিশটা কোথায়? 21শে আগস্ট।
আজকে অনেকদিন আগে গেল বেচারি এটা তো রিসেন্ট গতকালের অর্ডার গতকাল দিয়ে দিয়েছে তাহলে এখন হয়তো নাও দিতে পারে ও না 21/11 এক মাস আগে তো এক মাস আগে অনেক দেরি পেয়েছে yes your application is also at a belated stage in the month of November one work order is issued okay 21/11
No, Lordship.
আবার বলেন, this is pertaining to work order 2. See. This is-
What order 2? Kindly see, Lordship, page 56.
page
Yes, 56.
Your page 56.
My page 56, annexure fee 3.
Hmm.
Submission date 3rd June to the 30th June 2025.
Hmm.
I have submitted. Others also submitted on 29 or 30.
Arey Baba,
No, work
21st
order.
September,
Oh, work order. Yeah,
Work
yeah.
order is issued in the month of November. You have come in the month of December.
That is the problem, Lordship, because
A problem, what can we do then?
So far,
But-
this work order is concerned, you have come at a belated.
but the other
It is a-
they cannot produce even, Lordship.
I-
Another
I
thing,
think-
Lordship.
Work has started, she's saying, why she will make a
Regarding
mistake?
this work,
No, that is work order number 1. In work order 1, issued work is going on, but she cannot produce the work order.
Lordship, kindly then
Hmm.
direct one inquiry by a advocate, any advocate.
At your instance.
No, she's my submission.
No, we can appoint a special officer at your cost. It
Lordship,
has to be at your cost.
Lordship.
So, technicality কি?
ওকে বলছে জেনুইননেস না সত্যি ওয়ার্ক স্টার্ট করে গেছে
Lordship, kindly appreciate.
Started issue, creating confusion.
Lordship, kindly.
In that matter, that is true.
ওয়ার্ক অর্ডার
Kindly sees the quoted percentage
Yeah.
of the 5. I am not here. Kindly sees minus 7.210 and others 0.
So
something.
you are pleading malafide after work order issued. You are pleading malafide.
Lordship,
Parties are not there.
my-
They have not been implemented.
My
21st November work order issued. What you are doing after for the since
Lordship,
then?
regarding the other work, no work order has been placed.
She is submitting. We will record that. Anyway, even if it is taken into account, you have to add all those parties. Then the matter becomes unnecessarily complicated. We
Then-
could have understood that you have come immediately approach the court. Work order has not been issued. Trial judge, what is the wrong in the order? Trial judge has said that work order has been issued. I am not inclined to exercise discretion.
But Lordship, will the court not take into granted that this type of malafide intention and malafide process by the local offices, they're manipulating the government exchequer and public money to their person without following the rules, the guidelines? What was the intention of the legislature and the parliament to enact the e-tender? Because everything will be clear, everybody can approach. The transparency should be there.
You are fighting it so aloud, but see your conduct. See
Lordship,
your
my conduct is shown to be deleted in a deleted say as because those documents I humbly submit before the court was not there at that time. It was now placed, not even on affidavit.
Which one?
The document, the tender, work order, and the notice, it was not there in notice board, Lordship.
Court has recorded
No,
21st.
it is their submission that this was the document which has been affixed in the notice board. My submission is that I can file
Then
it
you
on
file
affidavit.
your affidavit.
Yes,
You
sir.
file your affidavit enclosing these two materials when a malafide is being alleged. Steps taken will abide by the result of the appeal,
Grateful, Lordship.
and you will.
Lordship, only in the only submission is that the serial number 2 work is completed.
We
And-
shall record that.
Yes, and
Whatever you have submitted, we will record. But we will invite affidavits on the ground. He has urged a ground that it was a e-online transfer, tender process.
Admitted.
Having done everything online, why did you only take up this issue of issuing a notice for production of originals on 20th? You can just.
I understand.
We are not in his favor because we said you cannot, it is not appreciable that a local contractor will, after submitting his bid, which says that there is a clause that production will not approach the panchayat office that you have made this in the tender when you are uploading and calling for submission of documents. So we were not with him, but in the case where previous works you have cancelled, that is also online you have done. So
Yes.
why haven't you published the notice online? You could have uploaded it.
Yes, your lordship, regarding that, lordship had on first occasion, lordship had directed me to take instruction in this matter as well. That's why the notice was not uploaded in the e-tender portal and why it was put up on the notice board. Lordship, I have taken an instruction from the answering respondent as well. I would like to hand over the.
What, tell us. No?
It is that considering that all the applicants applicants are local, that so the tactical bid office has come to know that all.
May I be permitted to show one document?
And he has been all the applicants, including this petitioner, has been reminded several times and personally informed to produce their documents before the office, before the tactical bid office. It is as per the instruction I'm submitting.
Lordship, may I?
Because there were some discrepancies which were found in his application and some other applications as well. That is why this physical verification was conducted. And it was also made part of the terms and regulations that applicants had to submit their documents as and when asked for.
Lordship, may I show one document, Lordship? May I show one document? Kindly see page 61. The person who has got Binod Lama, he quoted -7.
No, you submitted this. Just
And page 61, my was 10% less. Page 61. Below, Lordship. 10.01. 10.01. And Binod Lama got it in page 7, -7.
Is that a fact?
Yes,
Lordship,
sir.
this
It is indeed a fact that Vinod Lama has pleaded at a -7 point something, and this petitioner, as per his applications, had made his bid about
Page 61, Lordship.
-10.
-10. So I was the other one.
Lordship, he would have gotten the work, but if he had complied with all the terms and regulations, he had, Lordship, for consideration of an.
How did you, page 61, how did you disclose the price schedule without opening the financial bid?
It was submitted, Your Lordship.
Your financial bid was opened and this was submitted.
Lordship, financial was it was
15th.
58.
Huh.
58 and followed 56 and followed by 58. These were in the publishing portal as well.
No, financial bid. That this document, page 61, which he is showing, page 61 document is pertaining to what?
Part serial number.
Paper block load.
Paper block load.
But this is the percentage bill of quantity. This is not your price.
Lordship, less 10.01.
That is left. To see the top. Sir Ganguly, don't say whatever you like.
Lordship.
At the top, percentage BOU. That is the BOUQ rate which you submitted.
Lord,
That is
yes.
for the purpose of your credentials. This is not the financial bid.
Lordship, it was the Gram Panchayat financial, Lordship. Quoted rate in figures less 10% for the paper block.
Yes, now show your pleading that you have said that is the financial bid opening. So,
That reading, Lordship, I
then
apologize,
you
Lordship.
can
It was
argue
not-
anything
it was
you
not
like.
Drafted by me, Lordship.
Well, that does not mean that it has to be
Sorry.
taken.
But the thing is, Lordship, Lordship, can you come the financial bid?
Lordship, this document has been attached by the petitioner in the writ petition.
No, madam.
Not
So
from-
2406 and 2407 both have been dismissed.
Yes.
Because in that court arrived at a. Now in 2408, 16th of December, initially an order was passed.
Yes, 16th of December an order was passed because the serial numbers, work orders
1 and 2.
3, 4, 5.
This is 2408.
Yes, for 2408 it is pending, Lord.
This is the 2408. That
No, this application is for 2406.
Oh, this is 2406.
Yes, Your Lord.
So 2406 is pending.
2406
6 has been dismissed. And 2407 and 2408 are pending.
No, 2406 and 2407 has been dismissed.
I have not challenged 2407.
I see. Now 2408
It
is
is pending.
It is pending.
So we are dealing with 2406
2406 only.
2406 only. 2406.
with regard to two work orders.
Two work orders.
The paper wrote from the house of Provin, na? The house of
এইটা যদি বলেন যে না বাঁচিয়ে রাখুন
ওরা থেকে ওটা এভিডেন্সই কি বলে সরকার তথ্য বিষয়টা একটা মেলা ফিরে আছে
কোথায় মেলা ফুটিটা পাচ্ছেন
ওটাকে ফলো করছে না একজনের ক্যান্সেল হয়ে গেলে তারপর হঠাৎ করে আগে তো ক্যান্সেল করবো একটা প্রসেস করবো আর এটাকে নোটিস থেকে অন্য প্রসেস করবো প্রসিডিওরের মধ্যে ইরেগুলারিটি আছে আর কি ইউনিফর্মিটিটা নেই
Ashok, the present appeal has been preferred, challenging an order dated 15 December 2025, passed in a writ petition being WPA 2406 of 2025, which was preferred, inter alia praying for issuance of which was preferred. Petition করেছিল consider the representation. এই তো দেখুন না।
তাহলে বেটার রিপ্রেজেন্টেশন কনসিডার করতেই কথা বলতে হবে তাহলে আর দরকার নেই
You did not challenge also. See, Mr. Ganguly, your prayer, page 30. What is your prayer?
What? আচ্ছা আমাদের আর এত ফাটাকে করে দরকার কি the authority
Writ petition was in order experiment by the legislative
Authority কি করবে? ওরা এটাই বলবে যেটা এতক্ষণ আমাদের কাছে সাবমিট করলো। আপনি বলছেন ওয়ার্ড কোডার
আমরা তো আর স্যাপ তার বাইরে যাবো কি করবে ইটেটা রিলিজ ক্লেম করছি তার বাইরে আমরা
যাবো বিকজ আপনি ঢুকছেন আপনি বলছেন ওয়ার্ড কোডার কোনো ডাইসি আছে এটা ডিসাইডেড হয়নি সেই জন্য ঢুকছি
রিপ্রেজেন্টেশনের মধ্যে কিছু নট টু ইস্যু ওয়ার্ড ফলো
কোথায়
রিপ্রেজেন্টেশন
Where is your representation?
Your representation finally comes to
Page 63.
63. Yes, Lord. No, 62.
62.
What is your withdraw the results published in the auction?
So this is not considered and no decision is taken on this.
This can be considered. Writ petition was filed.
Oh, before consideration.
The honorable court.
It was on 20th November 2025.
Writ petition was filed on 24th, I think.
No. Writ petition was filed. I do not know.
No,
when
no,
the writ petition
December.
was filed. In the month of
December.
December, it was filed.
Yes.
This letter was given on 20th
Yes.
November.
24th November.
So,
But the answering respondent had received this letter, and just 2 or 4 days later, the writ petition had came before the
24th November it was filed.
24th November. The writ
So how can we help? Your prayer is
it was
for
not in a time-bound manner as well.
Ashok, which inter alia praying for issuance of necessary direction upon the respondents to withdraw the results published of e-auction dated 18 June 2025. Mr. Ganguly and advocate appearing. records would reveal that an e-auction notice was published on 18th of June 2025, inviting bidders to participate in respect of the tender schemes incorporated with the notice inviting. কি লিখলেন? Records reveal that
The auction notice was published on 18 June 2025, inviting bidders to
আচ্ছা,
participate.
e-auction notice ব্র্যাকেটে hereinafter referred to as NIT করে দিও। হ্যাঁ, yes,
Lordship, it was the representation was given on 20th November. 7 days period was given in the to consider. It was filed on 20th November after the
no, kindly come to whatever your junior is saying, you are uttering it.
Yes, sir. Page number 33.
Kindly see 33.
It has been endorsed.
Whatever junior says, you are uttering. See, page 33.
It has been endorsed on 24th of November, Your Lordship, by the Oath Commissioner.
yes, but it was not filed, Lordship. It was filed on
আসুন,
filing slip is
NIT bracket NIT করে দিয়েছো তো, for inviting bidders
filing 28.
To participate in respect of the tender schemes
incorporated with the said NIT. Stop. The writ petitioner stroke appellant participated in respect of the schemes under which scheme? Page 38, you applied for which two schemes?
Lordship, page 38.
1 and 2.
1 and 2.
1 and 2 number দেওয়া আছে, লিখে দাও, টেন্ডার স্কিম নাম্বারস 1 and 2.
Number is there 117340.
1 and 2 ব্র্যাকেটে applied for the
participated in this program scheme under tender number scheme
Under-
1 and 2.
under tender scheme plan ID number 11734013 plan ID numbers করবে NOS করে 11734013 and 11734035 upon uploading all necessary documents within 30th June. Stop. Thereafter, it was uploaded online. Thereafter, upon technical evaluation, was uploaded on 14 November 2025. Uh, 14 November 2025, and the date for opening of financial debit was fixed on 15 November 2025.
May I take a leave, Lordship?
Stop.
Yeah.
Stop. Stop. The technical bids of the appellant were rejected on a purported ground, quote unquote, a original document not submitted. Agreed thereby, the appellant submitted a representation on 20th November 25, and as the same was not considered, the writ petition was filed. Mr. Ganguly, learned advocate appearing for the appellant, submits. submits that the learned single judge abruptly rejected the writ petition and refused to exercise discretion observing inter alia that the work orders had been issued, but fact remains that no such work orders, no such, but fact remains that copies of such work orders no work, no work order had been issued. Refused to accept on observing inter alia that no work order had been issued without issuing necessary direction towards production of the said work orders. He further argues he further argues that an e-online process that he further argues that the online tender process was initiated by the state with an intent to for the purpose of transparency and fair play. All communications requiring all communications pertaining to the tender process to be uploaded online. So that uploaded online stuff. In the instant case, in the NIT, there was a specific clause to the effect that, quote unquote, all the related documents are to be produced in original সব block letters দিতে হবে to this office as and when will be asked, unquote. Page 36. However, after submission of bids, the participants were not informed of any date for production of the original documents. The appellant had no knowledge. Dates online, the intimation of the dates online. And as a consequence thereof, it did not come within the notice of the appellant. Online stuff. Line technically, there was a specific, however, online.
The particular informed about any
Date for production of the original documents online. Production of the original documents, stop. Informed online, were not informed online. Such infirmity as urged were glossed over by the learned single judge and no finding was returned on the same. Miss Rokit learned advocate appearing for the respondent number 2, however, denies and disputes the contention of Mr. Shandal and submits that a notice dated 21st November 2025, 21st August 2025 was affixed was put up in the notice board of the Gram Panchayat. Put up in the notice of the Gram Panchayat to enable all the bidders to submit the original documents. Stop. As all the bidders were in the locality, there was no requirement for uploading any such information online.
And on intelligence, they were personally informed several times.
Where?
That has been instructed to me.
But is, madam, you are all instruction lines you are producing, file your affidavits and that on record. Put that on record. She further submits that that a work order pertaining to that first work order.
Second.
Work order pertaining to
This one.
So this picture is for two. Okay. Two নিয়ে কোনো dispute নেই। 2 নম্বর এটা কাজ হয়ে গেছে।
আপনি কি রিভিশন অ্যাডমিট করতে বলছেন? That work orders pertaining to the wards under 1 and 2 have already been issued, and work pertaining to work order number 1, pertaining to and the work WRK pertaining to work order number 1 has already been completed. 2 has already been completed. In support thereof, she has placed before us the work order issued in respect of the work pertaining to the work order pertaining to construction of pavered block road from house of Probin to the house of Tilak Chhetri. However, she has not been able to place before this court the work order pertaining to construction of both side guard wall at Upper Milon Pool near Somaj House. That is all.
Yes.
In reply, Mr. Ganguly submits that though reply, Mr. Ganguly submits that in respect of other work orders, in reply, Mr. Ganguly submits. Where is that document? That in respect of this is which work order? This is which work order? That cancelled was.
Koram Singh work order number 7, 9 and 21 has been cancelled for not fulfilling the code.
7, 9 and 21. Mr. Ganguly submits that pertaining to work orders at serial number 7, 9 and 21, the tender process has been cancelled. the tender process has been cancelled and such decision was uploaded online. We have heard the learned advocates appearing for the respective parties and considered the materials on record. It is true in the NIT, it was categorically indicated that quote unquote all related documents are to be produced in original to this office as and when will be asked for. However, as regards production of the said documents, no date was specified. However, prima facie, no date was specified for production. No date was specified and informed to the bidders online. In respect of the work order 7, 9 and 21, the order was cancellation was also uploaded online. Prima facie, a procedure appears to have been adopted. Appears to have been adopted. Complying with all formalities towards uploading of documents online. In view thereof, the respondents are directed to file their affidavit in opposition by 13th January, by 9th January, 13th January, reply thereto if any be filed within 19th January. No, তখন তো আবার সার্কিট থাকবে না। No, you file it within. You file it within 7 days after the vacation. 6th. By 6th, reply thereto if any be filed within 9th, list the matter for further consideration subject to the convenience of the Honorable Circuit Bench on কত বললাম একটা 6 আরেকটা 9 on 13th January. It is made clear that all steps taken in the meantime shall abide by the result of the deed. We said all steps taken will abide by.
Lordship, item number 11, Your Lordship, I've mentioned in the morning, Your Lordship. It's an order 43 application.
Is there any caveat in that?
No caveat, Your Lordship. It's an extremely urgent matter, Your Lordship. My land is under, Your Lordship.
এই শোনো ওই অন্য ম্যাটার গুলো 1, 2 করে কল করে দাও, এই আইটেম নাম্বার 11টা দাও তো। Because that will be required at the time of signing. We check up now the documents. All right. কোথায় বলুন?
এর মধ্যে আছে
21st August. আচ্ছা, এটা ওনাকে দিয়ে দাও একটা। Then you give back a copy to us. Give back a copy to us. All right. Yes, এটা একটু দেখে দাও ম্যাটার।
interim order of stay যেটা আছে
6 and 7 I'm paying for next sir.
6 and
7, Your Lordship.
What you are for the?
I'm for the appellate.
You do not want to do it.
Then it's here, Mr. Bhutan Bhattacharya is appearing.
Okay, not today you want.
Next, sir.
Next circuit করে দাও। 6 and 7 থেকে একটু কল করে যাও না।
Lordship, item 11.
Wait, madam, wait. 7 থেকে ডেকে দাও তাড়াতাড়ি। 7, 8, 9, 10 করে দাও। Yes. Come back. One urgent matter has been called. We shall take your matter up tomorrow.
9, 10, 11.
11, Your Lordship. I'm
Yes,
appearing for
11.
the petition.
File the dog.
Yeah. Devotion.
Can you just inform Mr. Ganguly to come once? Because as we have said, it will abide by, you intimate to the tenderers this fact. Otherwise, unless this order.
Lordship, my senior is present, virtual.
Yes, yes. Item 11.
You are in such a hurry, but your advocate on record does not correct the error which is there.
Lordship, it was corrected. It was corrected. It was corrected on the first date. On Tuesday, it was corrected itself.
Yes, what is the order?
Lordship, the order impugned is at page 88.
No, running page 2.
Running page 2, Your Lordship. Lordship, I'll just only request, Devorshi, can you please place the order, page 88?
Yes, Lordship. It is order number 2 dated 3rd December 2025.
Just now, allow us 2 minutes.
Lordship.
Order dated 3rd December.
Yes, what was the interim
Lordship.
order you sought for?
Lordship, the interim order was sought for, Your Lordship. The prayer in the suit is starting from page 17 and the prayer is at page 27.
Yes.
Lordship may kindly takes page 27 of the application. Lordship, I had prayed
Yes.
for a decree for cancellation of the development agreement dated 28 September 2018, being such and such number. A decree for cancellation of the power of attorney, same dated. Now, the third prayer was a decree for recovery of possession of the suit land, evicting the defendants therefrom and restraining the plaintiffs therein.
Was
And
any letter that you issued after
Lordship,
2018?
no, Lordship. 2018 was the
You-
development agreement. Lordship, the only reason for rejecting the interim order, Lordship, I had come before the learned court at the ad interim stage. Lordship,
Yes.
I'll be referring to only.
Show us from the date of execution of that agreement till 8 years, when the
Lordship, 8
materials
years.
were dumped, any
Lordship.
single letter was issued to
No,
by you
no
that
single
unless you
letter,
start
no
work,
single letter, no single
then
letter from
then
my
what
side
is the
and from their
wrong?
side. Lordship, Lordship, now.
So
No,
then,
what,
madam, what is the
your
wrong with
interim
you?
order, you see, mandatory injunction, what you have claimed in the, as a final relief cannot be granted at the interim stage.
Lordship, I bow down to that.
So
Lordship,
what interim relief can be granted?
I have only prayed that in the meantime, this is my land. Lordship, let me only place the matter in a very nutshell. My land. I have entered into a development agreement dated 28th of September 2018. Now, that agreement was time bound to the effect clause 12.1. I'll be only placing one clause, only one very relevant clause. Page 47.
Now, why you are so reluctant to ask the court to hear after service is over? At
Lordship,
interim stage, why?
Lordship, kindly do not take me amiss. I cannot be reluctant, Your Lordship. I am
No,
ready
that
and
is
willing
why.
the matter to be heard. Lordship,
Right,
only
let
in
it
the
be
meantime.
heard.
Lordship,
Matter
only
is
in the
fixed on
meantime.
14th of January. Let it be heard on
Lordship,
14th.
Lordship, only in the meantime, Your Lordship. What was the difficulty which made me pray for an ad interim injunction is that in the non-existence of the development agreement. Lordship, the development agreement was of 2018.
Yes, which page is your application for injunction? Which page?
Lordship, the injunction application is at page Annexure D.
Nature of character of the land.
I am only praying that nature Annexure D, Your Lordship.
Reason to দিয়েছে যে
করে নিলাম এগ্রিমেন্টটা টার্মিনেট করে যদি আবার কনস্ট্রাক্ট করে কি থার্ড পার্টি কি ঢুকিয়ে দেয়
Lordship, only the third party difficulty is there.
এগ্রিমেন্টটা হয়েছে 8 বছরের কোর্ট বলেছে নোটিশ লাগছে কিন্তু প্রাইম অফিসে আমি দেখি কাজ করে
Injunction is page 76.
Just one.
Lordship.
এখন আপনি বলছেন না ডোন্ট ওয়েট ফর অর্ডার তাহলে আপনি অর্ডার দিয়ে দিলে হোয়াট উইল বি ডিসাইডেড ইন দি ইন্টারিম স্টেজ
ল্যান্ডে কিছুদিনের জন্য 4 সপ্তাহের জন্য টিল দ্য ম্যাটার ইজ টেকেন আপ 4 সপ্তাহ
ভাই
যেহেতু ল্যান্ডের ক্যারেক্টারটা যদি ও যেটা করছে থার্ড পার্টিকে যাতে এলিমিনেশন না করে ওই ইস্যুতে
বিষ্ণুবাবু আপনি লোক আপনি যদি বলেন আমাকে কি সুন্দর একটা দিন দিতে হবে
Lordship, may I? The injunction application starts from page 76. Lordship, here there is an development agreement, which has lost its effect after 4 years. The clause 12.1 categorically provided a 48 months time frame. Lordship, my ad interim stage, I am not even at the interim stage. At the ad interim stage, an injunction is rejected on the ground that I have not served notice. My submission.
Not rejected, your contention has been deferred. That you serve upon them and come back on 14.
I am only.
Today, if we pass an interim order in your favor,
only for a limited period.
No, what remains for discussion? If we prima facie express our opinion, then the injunction application itself become infractual.
Lordship, then it will create a third party right, Your Lordship. Then that gives rise to multiplicity of proceedings, Your Lordship. I will be aggrieved.
8 years after 8 years, you are raising your voice.
Lordship, not after 8 years, Your Lordship. I was in communication. It is not that, Your Lordship.
Show us one document. That is what we are asking.
Lordship, that is what is the difficult.
Show us.
Lordship, there was no exchange of documents, Your Lordship. Lordship, I'm only praying. They have now dumped the materials.
We express a prima facie opinion what remains in the injunction application.
Either is it laws, balance of convenience, or exigency, huge opportunity.
Only for ad interim stage, Your Lordship, I'm entitled to a protection under the law where Order 39, Rule 1 and 2, that specifically provides if I am able to make out a prima facie case and the balance of convenience and inconvenience is tilted in my favor because it is my land. The agreement has expired. Third party rights are created.
Where third party right created? Anything you will submit.
Lordship,
Where have
kindly-
you pleaded third
Lordship,
party right created?
that I've pleaded, your Lordship,
Yeah, where?
in my
Show.
in the injunction application. Injunction, Lordship. I bow down to that, your Lordship. Kindly takes page 84. Page 84 of my present application.
Which paragraph?
Page 40.
Paragraph 48. The
48.
plaintiff that if the defendant and main and agents are not immediately destined from constructing over the suit
What
land-
was your senior submission? Did you hear what did she
Yes,
submit?
third party
That they are creating third party right will be created. Where?
Yes, I will play that. If
Page
they are not
para
restrained
48.
from creating third party interest in the suitland, the defendant would cause wastage of the suitland and create multiple interest based on their possession over the suitland.
What?
That is my submission.
14 January mattered fixed. You are wanting us to return a finding on that. 14
Lordship,
January mattered fixed.
we are
And
being
today they will
aggrieved.
raise a 5-storied building there within 15 days.
Lordship, even one letter is issued, Lordship. Lordship, may kindly appreciate, your Lordship. The cause of action started not today. It has started from the month of November, your Lordship. That is also pleaded in my injunction application, para 47 onwards. The cause of action is from 17 November 2025. The cause of action started from 17. কোর্ট চলছে একটু আসতে বলতে বলো। Lordship, I'll be referring to one judgment only which provides some protection at the ad interim stage. 1990 to 1 SCC, page 719.
That was an execution case, this order was passed.
Lordship, it was passed in the execution case, but I am only, Lordship,
Where, which
restricting my
portion you are
submission.
referring?
Lordship.
Which portion you are referring?
Lordship, I am only referring to that existence of a prima facie case must be shown by the plaintiff.
Maximum din not change the nature and profit.
That order, paragraph 4, that order 39 rule 1C provides the temporary injunction may be granted where
Yes, learned
Lordship.
advocate for the plaintiff appellant is present. Our learned advocate for the plaintiff appellant produce the materials on record. This appeal is directed against refusal of the learned learned civil judge senior division, Shiliguri, in refusing to pass ad interim order of injunction by order dated 3/12/2025
Lordship.
Upon considering the nature of the suit and the order appealed against, we are of the view that this appeal should be admitted. Thus, we admit this appeal.
Grateful, my lord.
However, as or by the plaintiff appellant in the suit was that, yes, which page?
Yes.
70?
76.
is my injunction application, Lordship.
76, the
That-
injunction application
that
starts.
the defendants be restrained from making any construction over the suit property and from restraining the defendants, their main agents, from changing the nature and character and possession of the suit land, and from restraining the defendants from creating any third-party interest. Stop.
Grateful, my lord.
Upon producing the order dated, upon producing the order passed by the learned trial court, learned trial court has also relied upon the order, the judgment passed by the.
It has not relied.
No, no, no.
Trial court বলছেন তো আপনি।
The appellant in the instant case has relied upon a judgment passed by the Honorable Supreme Court in the case of Dalpat Kumar and another versus Prahlad Singh and others, reported in 1992, 1 SCC, page 719.
Right.
Stop. Upon considering the decision and considering the facts of the case, this court, we are of the view that as the date or next date is already fixed on 14/1/2026, in the interest of justice, only a limited order should be passed for protection of the suit property. Thus, the defendants respondents are restrained by an order of injunction from changing the nature and character of the suit property and from making construction thereon for a period of 4 weeks from date, for a period of 5 weeks from date.
Grateful, my lord.
Let notice be issued upon the respondents and the affidavit of service be filed. Let the matter be placed before the next available circuit.
Grateful, my lord.
Application. Yes.
Item number one.
Yes. $24. By reason of a typographical error in the first title of the order dated 18/12/2025, the number of the matter has been incorporated as quote unquote CRM bracket A 861 of 2025 unquote in place instead of CRM A 861 of 2024. Office is directed to effect necessary correction.
Item number two.
Item number two, based on short person, 45. All Indian this is the series. No. I am apprising your lordship. On last occasion, the matter was heard by your lordship. Your lordship was pleased to ask me to get some instruction.
Yes, yes.
But I can.
Yes, yes.
Actual fact is that a civil dispute, and my mother in the meantime expired. So if possible, your lordship's correction, we fix to the next circuit. Because there is an agreement for sale.
Did you take instruction whether you are giving that amount?
My lord, I can give the amount, but in the meantime, my mother expired a few days ago. So he is 2 months time. In the meantime, if possible, the interim protection may be allowed. With an undertaking from my end, that I will pay the amount.
On the prayer of what?
On the basis of my prayer.
How can you make that prayer, sir? How can I allow you to make such litigation? You are not the litigant, no? Why you are embarrassing yourself? On the prayer of Mr. Bhumik and advocate appearing for the petitioner, the matter stands. Petitioner, the matter stands adjourned. Please the matter before the next available session.
Item number three.
Who is appearing? Tell us what is the matter. Call him, go and call him.
But allegation is that two persons, everyone Shonai Gondor and Krishna spy were apprehended by the police along with 10 kilo gaja. 10 kilo gaja is for a kilo commercial conflict. 37 is not a part. And nothing has been removed from my possession on the basis of the statement of the two-act.
Yes, where is Sujoy? Who is your other side? Where is he?
On the wall, from the state, and on the wall. I think the board of the any passport sometimes can be taken up after 5 minutes also. Then
But after taking the relaxation, after taking up the relaxation, you have to go.
Relaxation, which matter?
But after taking up all the relaxation, this matter.
Relaxation matters are not there. Oh, acha. All right, yes. Passport.
Item number 4.
Who is your other side? Sir, what is happening? No state lawyer is there.
Lots of my practice at levels were
Just wait, Mr. Kumar, please.
item number 3.
Yes, what do you say? He has told me. Charge sheet has been submitted. So below commercial quantity, charge sheet submitted.
Charge sheet has been submitted on 23rd of October 2023.
Apprehending as the present learned Mr. Bhomik learned advocate, Guho learned advocate appearing for the petitioners submits that there had been no recovery of contraband substance from the petitioners and their names have transferred on the basis of co-accused statements pertaining to a purported recovery of below commercial quantity contraband substance. In the said conspectus, custodial interrogation may not be necessary. Mr. Misro, learned advocate, appearing for the state, has opposed Mr. Roy's prayer. Mr. Misro, learned advocate, appearing for this, opposes the prayer of Mr. Roy and submits that there are incriminating materials on record against the petitioner and stop answering the query of this court, he submits that upon completion of investigation, charge sheet has also been submitted. Having heard the learned advocates and considering the materials on record, and since the dispute pertains to recovery of contraband substance below commercial quantity, and as the petitioner's apostrophe is that the petitioner's names have transpired on the basis of co-accused statement, prima facie, the regards of section 37 of the NDPS Act are not attracted. In view thereof, allowed 10,000 to CODTs, 1 local, 40 to 3. Yes, number.
Item number 4.
Yes. Charge sheet submitted. Yes, Mr. Chakra.
Which one you want? Relax, modify or just back it? That's not the right.
Requires a mark of the year, it will be something of the final number.
Charge sheet submitted, I go ahead.
I asked him what he has prayed for, either relaxation, modification or bracketing. The condition.
That depends upon the circumstances.
If it is relaxation, then it can be relaxed, my lord, from 12 to 1 month.
Charge sheet submitted, but
Where have you stated that, sir? I need to IPC to regulate to the 800, is it? IPC or DL? At a 4? You have been released on bail.
here by this court, thereafter I submitted bail, regular bail obtained.
Then what remains of this order? You have obtained regular bail.
Regular bail, there is a direction, I need the IOT till submission of the charge.
That is not required because you have I don't know what conditions have been incorporated in your bail prayer.
It's written key in
Your bail order you have
the
annexed.
petitioner shall appear before the IOT twice in a month on the day and the time fixed by the IOT till submission of the final form. So if you submission, the charge sheet is filed, it's not final form, it has been submitted, so.
So what remains to be?
Now, court order by the honorable high court, otherwise.
He needs the order.
Otherwise, then.
No, what do you apprehend, Mr.
Charge sheet submitted, otherwise the OMT comes. Otherwise.
No, after charge sheet you have appeared and obtained regular bail. So regular bail must have been on some condition.
What should be the high court? There is no other condition.
Oh, also.
Obtaining regular bail, I surrender and from obtaining, maintaining all formalities.
Mr. Poddar, learned advocate appearing for the petitioner submits that the conditions incorporated in the order dated 31st October 2022 have been substantially complied with by the petitioner, and upon completion of investigation, charge sheet has also been submitted. And accordingly prays for waiver of the direction upon the petitioner to meet the IO twice in a month. Mr. Chakraborty, yes, what do you say? Mr. Chakraborty, learned APP appearing for the state. Enters appearance on the as the charge sheet, as upon completion of investigation, charge sheet has been submitted, and as it appears that the order dated 31st August 2022 has been substantially complied with, the direction to the effect that the petitioner's final form, is waived, the application is dismissed. Yes, next.
You know, 5.
এই কাটটি হতে এরকম করে দাও এই যে অত বড় লিখতে হবে হার্ড বি লার্নেড অ্যাডভোকেটস consider the materials of the record stop তারপর লিখবে it appears that it appears that the petitioner had substantially complied with the directions contained in the order dated at till date, and as upon completion of the investigation, charge sheet has already been filed, the condition has incorporated in the order to the effect that is waived. The application is disposed of. Yes. Meet with the once in a week. This is yours, next one. Item
Yes, madam. Yes, sir. The order, madam.
meet with the order. Your charge sheet submitted.
Yes, madam. Madam, madam, that is submitted. So, madam,
Yes, আগেরটাই
Two conditions are there. One is to meet the once in a week.
we are not, that is waived and the others will
Others will.
remain.
Appear before the
Hardly learned is appearing for the respective parties and consider the materials on record. Stop. It appears that the conditions incorporated in the order dated 27 November 2024 had been substantially complied with by the petitioner till date. And as upon completion of investigation, charge sheet has also been filed, the condition as incorporated in the order dated with such and such to the effect that quote unquote the petitioner shall meet the concerned investigating officer once a week unquote, comma, is waived. The application is disposed of.
Item number 8.
Thana Ajira, my lord, he has prayed for. That Thana Ajira he has prayed for.
Same order করিয়ে দিই এই পেজ 8 এর পোর্শনটা একটু কোট আনকোট সব পেন ড্রাইভে পাঠাবে সব yes ওদেরকেও বলে দেবে
Number 7.
My lord, here bail was granted on 20th January 2025. Now he appeared and seek modification or relaxation to surrender before the court, my lord, after a lapse of 11 months.
ফাইলটা দাও order was of 20th
January 2025.
Well acquired person paid for anticipated duty. This was
Paid for duty.
allowed by this honorable court panel. In respect of all of them, only one petitioner, petitioner number 3, this Chandra Bhargava, my lord, he was unable to admit the surety amount. For this reason, he unable to appear before this court. So there is, I should about 1 week. Now I able to admit the surety money, but I want
My lord, to make this, it took 11 month time, my lord.
what is your explanation that is no explanation Mr. that you have told the court at that juncture you could have told the court at that juncture do not put this condition in the case even after getting the benefit you do not take what can we do that is provided I allow no there must be some explanation it is not a group case
What person political benefit are the implicated instant case, my lord.
My lord, I have come.
This system, my lord, with some benefit,
Right.
my lord, I will.
He may took the plea during the 4 weeks, my lord. During the 4 weeks, which time the at the bail petition, the bail order, court honorable court provide. During this time, he put the question, my lord, regarding the money, surety money. Why after 11 months, my lord?
Paying before your lordship, my lord, all are signed here, I will expect.
the
Why
present
after 11 months?
application has been preferred praying for relaxation of the conditions provided in the order granting anticipatory bail to the petitioner herein and 5 others on 20th January 25. Mr. Poddar submits that the present petitioner is extremely poor and he could not arrange the surety money and as such could not surrender before the court. Within the period as directed. Mr. Learned Advocate appeal for the state opposes such prayer of Mr. Poddar and submits that the instant application has been filed about 11 months after the last order granting anticipatory bail was passed. Heard the learned advocates and considered the materials on record. The explanation towards the delay in preferring the application is not acceptable to this court, and accordingly the application is dismissed. Yes.
Grateful, my lord.
4 weeks, I am not allowed, they will not arrest me also, my lord.
We have to follow a procedure.
You are very much clever to feed us from the justice, man.
This which what is the harm to the prosecution, my lord?
We heard you, Mr. Pillar. Yes, next.
Grateful, man.
Number 8. Two securities of 10,000 each of whom must be local to the satisfaction of the arresting officer. Question petition is belongs to very poor family, and that's why he was unable to finance the local law. Just kindly modify the local law into a local surety into a registered surety.
$20,000 each.
Each of whom
This was anticipatory bail. No, this was regular bail.
Anticipatory bail was
No.
allowed.
430, page 13. Page 13 of your petition. Subhash Burman. Come to the order which was passed. Oh, 28th July.
That's on page number 6.
Then what is this order? 4th of April, not in your case.
No.
Then application, yes,
CRM 565.
560. This order was July. So with 2 registered sureties.
Each one of whom must be local.
So what you are wanting? Local you could not arrange.
Is that a long time, a lot of rounds are very genuine.
Heard the learned advocates appearing for the respective parties and consider the materials on record. This court is satisfied with the explanation given by the petitioner in not being able to arrange 2 registered sureties of 10,000 each, one of whom must be local to the satisfaction of the arresting officer. Stop accordingly. The said condition is relaxed to the effect that That. It's modified to the effect that in the event of arrest, the petitioner shall be released on bail upon furnishing rupees 20,000 with two registered sureties of 10,000 each to the satisfaction of the arresting officer. The application in such and such is disposed of. Yes.
Item number 9.
Sir, restoration. A case was dismissed for default file. I was in group number 2, when the case was called, I couldn't reach my, the case was dismissed for default.
So you don't have any friend of yours? Nobody responded. Upon hearing the learned advocates appearing for the respective parties and considering the materials on record, this court is satisfied with the explanation given towards the absence of the learned advocate of the petitioner before the court. When of the petitioners before the court when the matter was dismissed for default on 18 November 2025. Accordingly, the said order dated 18 November 2025 is recalled and the application for anticipated bail is restored to its original filer number. Stop the application being such and such is accordingly disposed of.
Item number 10.
Yes, but 493 of the Indian Code and 494 of the Indian. But petitioner is the husband. But 7 years ago, marriage was solemnized. My allegation is that on 21st of November 2024, the accused person assaulted the complainant and tried to kill her by force. That is that. And thereafter, he was taken to the hospital. Thereafter, he took shelter to her father's house. After 8 months, that is on 12 July 2025, but she lost this complaint against the petitioner and his family members. And there is no delay. Well, there is no
Attempt to murder. Attempt to murder. 307 is there.
But after 8 months.
No, when was your marriage solemnized?
After 7 years ago. 7 years.
7 months.
7 years ago, marriage was solemnized.
Very good. Then?
Alright, thereafter 21st of November 2024, as per the FIR, the accused person assaulted the complainant and tried to kill her by forcery. That is the allegation. Thereafter, the local people rushed to the spot and rescued her. Thereafter, she was admitted to the hospital. Thereafter, she took shelter to her father's house. But after 8 months, on 12 July 2025, but this complaint has been lodged against the petitioner and the other family members. Other family members were granted anticipatory bail by the learned session judge.
Charge sheet submitted.
Charge sheet submitted on 31st of August 2025.
What is the injury, Mr.?
Injury, I have it was in a nursing home, private nursing home, my lord.
Private nursing home.
There is no expression of delay, madam. 8 months after the incident. All other person granted.
Apprehending arrest, present application, Mr. Google and advocate appearing for the petitioner submits that the dispute pertains to an incident which occurred about 7 years after the marriage. Stop. The stop. Oh, 7 years. Stop. The such alleged fact was reported by way of a complaint about 8 months after the alleged incident. Stop. Upon completion of stop, no specific overt act has been attributed to the petitioner, and upon completion of investigation, charge sheet has been submitted. Mr. Chakravarti and DPP opposes Mr. Guho's prayer, drawing the attention of this court to the injury report and the statements of the witnesses. Any 164, Mr.
No, my lord. 161 was there, page 5, 9, 10, 11, and 12.
For hearing the and statements of the witness upon having heard the learned advocates and considering the materials on record, comma, the nature of acquisitions, comma, the injury report, and the extent of complicity of the petitioner in the arrest offense. I am of the opinion that custodial interrogation of the petitioner is not necessary. More so when upon completion of investigation, charge sheet has been submitted. Allowed 10,000 to 1 per court equal.
Item number 11.
Mr. Guho, when was the charge sheet submitted? It's left.
August 31st of 2020.
Where and she is residing at her paternal house. That is in which village? With a further condition করে দেবে. Again.
That is in Baniyadaho, post office, Nandina, Sahibganj, Thana Sahibganj.
Oh, same. Parental house and matrimonial house same.
Under same PS, but villages are different.
Then where does the girl reside?
Girl resides at sir.
Paternal
Paternal house is in Baniyadaho. Baniyadaho.
আচ্ছা ওই একেবারে মিস্টার গুহর সাবমিটের দিকে the petitioner is residing presently the de facto complainant is residing at her paternal house in the village Baniyadaho, with further condition that the petitioner shall not enter the jurisdiction of Baniyadaho village, enter the jurisdiction of Baniyadaho village until further orders.
Number 11.
Yes, petitioner. No one appears on behalf of the petitioner, and no accommodation has been sought for, though Mr. Luxam, learned advocate appearing for the state, is present. In view thereof, the matter stands adjourned. Establish the matter before the next available site. Yes, next.
Item number 12.
Let him start. Call him. Yes.
447, 323, 325, 376, 511 of the Indian Penal Code. That allegation is not attempt to rape. 511.
376 is there.
76, 511.
No, no, it
Number
match.
323, 325 are
Onupul Sarkar.
But only one non-bailable offenses 376, 511.
That is corresponding to section.
But section mallet 64 and 62 PLS.
Who are you? You are.
I would for that. Aged about 75 years old. Our allegation is that on 23rd of July, the petitioner, the house of the petitioner and the house of the defector complaint are they are the next door neighbor. There is a boundary dispute between the parties.
So you preferred an application for 156?
No, I am not. Yes, I am the
Husband file.
The complainant has prepared an application under 156. But the incident.
The husband of the victim.
Yes, husband of the victim.
Against this person.
Against this.
Onukul.
Yes.
All right.
Yes, start.
Yes, yes.
On allegation is that on 23rd of July 2025 at about 3 p.m. this Onukul Sarkar being armed with a dao had entered into the room of this victim house. At that time, the husband of the victim was not present in the house. As per the and when he entered the room, this petitioner saw that she was sleeping. At that time, he was trying to rape her. When she started shouting, this petitioner came out from the house. And at that time, she was sustained injury by the petitioner. Well, that is the allegation. First of all, my lord, after 15 days.
Now what, this incident was on July 25. Charge sheet has not been submitted. I think.
Kindly consider one. But these are person of 75 years old. 75 years old, can rape a person.
That we cannot say. Let us not discuss that here.
Actually, on this false allegation, there is a boundary dispute between the parties. Out of the this case has been started. After 15 days of the alleged incident, 156(3) has been started.
This is the 164 issue.
But neighbors out there, they have also seen this petitioner running out.
But allegation of rape are absolutely false, man. And other section are available regarding assault.
Apprehending and present applications where Mr. Guru learned appearing for the petitioner submits that the petitioner is 75 years old and the alleged incident was reported and the complaint was lodged about 7 days after the 15 days after the alleged incident. Stop. An exaggerated account of the incident was incorporated and the petitioner was falsely implicated. as there is no possibility that the petitioner would flee from justice, comma, he may be granted anticipatory bail on any condition. Mr. Chaudhary Anil Bukit appearing for the state opposes the petitioner's prayer and draws the attention of this court to the statement of the victim as recorded under section 185, 183 of the DNS.
One intelligence, with regard to the delay in lodging FIR, the written complaint was informed on 26th of 7th, 2025. But no FIR was registered, and only PG sale number, that is public grievances sale number, was given. But no formal FIR was registered, Thereafter, superintendent of police also have been informed, but no fruitful result came, Then the complaint gets started.
The learned advocate appearing for the de facto complainant submits that immediately after the incident, comma, such fact was reported by the such report to the such fact was reported, but as the complaint was not accepted, he was the de facto complainant.
Complaint has been accepted. It was honored. Yeah. There is no
To treat it as an FIR, that is why 175.
it was.
Mr. Nautaketed, Mr. What is your name, sir?
Mr. Ghosh.
Mr. Ghosh, learned advocate appearing for the de facto complainant is the husband.
De facto complainant is the
Wife. It
wife.
the de facto appearing for the submits that the delay occurred due to non-acceptance of the delay occurred as initially it was not registered as FIR. Mr. Sajan learned advocate appearing for the de facto complainant submits that the petition and that the said complainant had to approach the appropriate court for treating her complaint as an FIR, and pursuant to an order passed in the same, the complaint, the FIR was registered. And in view there, and as such, it is not a case that the de facto complainant had intentionally delayed in lodging the complaint. Having heard the learned advocates appearing for the respective parties, the statement of the victim lady as recorded under section 1, comma, the nature of acquisitions and the extent of complicity of the petitioner in the alleged offence, comma, and not inclined to exercise discretion in his favor, more so when upon completion of investigation, charge sheet has not yet been submitted. Dismissed, yes.
My lord, 13, I am for the petitioner, my lord. My lord, the present petitioner, my lord, my lord, my junior friend is over there, my lord. My lord, the present petitioner is a lady. My lord, the present petitioner is right now in an advanced stage of her pregnancy, my lord. She is 7.5 months, my lord, pregnant, my lord. And the allegation is that on 11th of February, there was a quarrel between the neighbors. Two of the accused persons, co-accused persons, that is Bushal Orao and Kushal Orao, they assaulted the victim lady. As a result, my lord, she succumbed to the injury. She was taken to the hospital, she succumbed to the injury. Thereafter, my lord, these Bushal Orao and Kushal Orao, they were arrested. They have been granted bail by the learned court below.
Just
my lord, my lord, my lord.
Hmm. Charge sheet submitted?
Yes, my lord. My lord, I have annexed it also, my lord. It has been submitted. It is my annexure P4, my lord, page 19. In the month of, my lord, April, my lord, it has been submitted. My lord, page,
Why didn't you go and approach for regular bail? Charge
my lord,
sheet
only
submitted.
my difficulty is, my lord, right now she is 7.5 months here old, my lord. She is
So
pregnant,
at
my lord.
that time you were not so. At the time the matter happened, charge sheet has been submitted in the month of April
But my lord,
2025.
yes, my
And
lord,
you
this
filed
lady,
you filed this application before this court on
my lord,
September
September.
20. Then
Yes, my lord.
how can you take that plea now?
No, no, my
Go
lord, only one.
appear and obtain regular bail. There
My
is
lord, my lord, if some protection, my lord, can be given, my lord,
what
because
protection I can give.
my lord, she is in a very, my
But
lord,
what is the allegation in the charge sheet against her?
my lord, kindly sees all. She was the victim was hit with a with a wooden stick, my lord. My lord, how can three of the three accused persons, hit with a stick, my lord? Only one blow. Kindly sees, my lord. And my lord, the primary co-accused persons. My lord, the primary accused persons, they have been granted. They were arrested, my lord. After suffering custody, my lord, they have been granted bail, my lord.
Yes, give us. Accused was again. How many accused persons were there?
My lord,
Three.
altogether 3, yes, my lord. The primary accused persons are Bushal Orao and Kushal Orao. They have been granted a bail, my lord. They were
Then what is
arrested.
the allegation against you?
My lord, that is something which is surprising. My lord, nothing, only the allegation is that I was present
Yes,
there.
have you checked it up?
My lord, yes, there are two eyewitness, 17 and 14, my lord.
Yes.
As to 164 statement, page number is not there. I have marked the pages. My lord, one more thing.
Did you find anything incriminating?
Yes, my lord, only overt. Nothing, my lord. No overt, my lord.
Section 5 subsection 3 is there. Section 3 subsection 5 is there, my lord. That brings the act under the joint, that refers to the joint constructive criminal liability.
But my lord, there has to be an overt, my lord.
Sir, we have heard you.
I'm sorry, my lord.
What is the relation of this lady with the accused? Wife. The petitioner here and the accused person. Neighbor.
Same allegation is there.
What is the name?
My lord, my
Sir, wait. It is very disturbing, first of all, to hear you on the video conference. I have heard you, now wait, let him show me the dog.
Petition is read out. She was submitted in month of April 2024. Right.
160. When did the death occur? Death occur immediately.
Yes, ma'am. PM report page 42, head injury.
So the common allegation against those three.
Also,
My lord, only one thing, my lord.
common intention is there, my lord. That is why section 3 subsection.
My lord, kindly sees one blow, my lord.
I will not hear your matter. Try before the next week.
My lord, kindly pardon me.
You don't listen also what is being said.
My lord, kindly pardon me, my lord.
Now, was this lady's application rejected by the session judge?
Yes, sir. Yes. Section P1. Page photo, I'm not sure. Page 7 after that. Perfection.
The next month, my lord, just after the session.
So 164 is of the eyewitnesses.
There is no page number, I have marked the pages.
Was there any recovery?
No, my lord. It's they done it quarterly and instantly it happened. Nothing like matter goes concealed or something.
But who struck the blow? It must have been a blow from one person, no?
It joint action.
But three persons, how can they join to strike a blow? Any other document? Please show us the postmortem report.
Page 40.
Page
42. Multiple injuries are there. So it may happen that each of them had
now
given
the fatal blow was, it is very difficult to assess.
difficult to ascertain at this stage, and then the doctor is examining.
She's a pregnant lady. She's a pregnant lady.
They am living entirely upon my mind. I don't-
Apprehending arrest present application is being prepared. The Mr. Buhola, appearing for the petitioner, submits that the petitioner is presently is at an advanced stage of pregnancy of about 8 months. Stuff. She has been falsely implicated in the alleged incident. No specific overt act has been attributed to the petitioner. There is also no possibility that she would flee from justice. In the said conspectus, custodial interrogation may not be necessary, more so when upon completion of investigation, charge sheet has been filed and the principal accused persons have already been enlarged on bail by the learned sessions judge. Mr. Bishas, learned advocate appearing for the state, has opposes the prayer of the petitioner and submits that there are strong incriminating materials on record against the petitioner, and in support of such contention, he has drawn the attention of this court the statement of the witnesses, the postmortem report, including the statement of witnesses and the postmortem report. Hardly learned advocates appearing for the respective parties and consider the materials on record. Prima facie, it appears that having hardly learned advocates and considering the materials on record, the statements of witnesses, including the statement of witnesses, and the extent of complicity of the petitioner. I am of the opinion, on the extent of complicity and the fact that she is at an advanced stage of pregnancy. I am of the opinion that her custodial detention is not necessary, more so when prima facie does not appear that there is any that she would flee from justice. And as upon completion of investigation, charge sheet has been filed and the other co-accused persons have already been granted bail. Allowed 10,000 to shield is one local 482(3), 482 দেখে নেবে, with a further condition that she will not leave the jurisdiction of which police station, Mr. Bishop?
Kalchini Pula.
Kalchini
But
police.
I have one point.
Yes, yes.
Kalchini is a remote place in Alipurduar district. My lord. The medical facility is not good in Kalchini.
Oh, I see.
If this condition is imposed, my lord, ultimate goal of granting bail will be, will suffer.
Thank you, Mr. Vicious. I was not aware of. তাহলে ওইটা 482 ছিল। Yes. Yes, next.
Item number 14.
क्या घड़ी भी लाया हुआ है, सर्विस ड्यू भी ला दिए हैं।
You
No, just you can see.
Allegation, my lord, against 341, 323, 373.
Service complete.
Service complete, my lord, then is now received.
Not received.
My lord, kindly proceed to more, my lord.
No, no. Have they received it? Have they got it?
That post office they received, my lord.
That is not there. Then how can we?
Then one gets one only.
Yes. Not today.
Item number
Can you
15.
get it within a day?
My lord, on that post office.
Yes, next. Who is he? Who is opposing him? NDPS.
Execution of murder, cultivation of murder. Cannabis supplier. But only 8 cannabis plant were recovered from the place of offense.
Your land.
No, but that was not murder. Stated in the murder, as per the murder. Allegation, we are cultivating, that land belongs to us or not, that was murder. 8 plants were murder recovered. Only 8 plants. Not out of political.
Name of the petitioner is there. From the house of Babura.
The other petitioners also they are murdered. Lakshman Sarkar, Jivan Sarkar,
Where it was seized from Mitali Sarkar, Jivan Sarkar.
It was seized from the wife of Jivan Sarkar, that is petitioner number 3.
No, how can it be seized? It was collected, 8 plants were. How the seizure is done?
Seizure is done, it was seized from the house of Babulal Sarkar. 4 pallets written up. Place of seizure.
Place from whom seized?
From whom seized, Mitali Sarkar, wife of Jivan Sarkar. Jivan Sarkar is petitioner number 3. For page number 41 and 42, 151 statement of the seizure witnesses are there. Charge sheet has been filed. Total there are 16 witnesses. Charge sheet filed on 19th of February 25.
So, which document you are saying, Mr. Chaudhary? Seizure list you have shown.
This is page number 41 and 42. Statement of seizure witness.
That cannot be an excuse. That cannot.
Below commercial. That was below commercial.
So below commercial in what sense?
But
It is under section. Is any commercial quantity involved? Then extracted from that commercial will come.
8 grams village area
So why do you apprehending arrest the present application has been go and obtain it. Mr. Guru Learned Advocate appearing for the petitioner submits that the petitioners have been falsely implicated on the rudiments of unfounded allegations. Upon completion of investigation, charge sheet has also been submitted, has been filed, and as such, custodial interrogation may not be necessary. So Chakraborty Learned State opposes such prayer and draws the attention of this court to the seizure list and the statement of the witnesses. Having heard the learned advocates and considering the documents in the case diary, the nature of acquisitions, and the extent of complicity of the petitioner in the alleged offence. Petitioners in the alleged nature of acquisitions. I am not inclined to exercise discretion in their favor. Accordingly, dismissed. Yes,
16.
Not today.
Number 17.
16 not today, then it will be taken up tomorrow. You be ready?
Lordship, ready for the city, Lordship.
Item?
16, Lordship.
What is the allegation?
7 to try to take instruction, madam. I said instruction.
NDPS.
Yes, Lordship. 50 kgs of gaza.
No.
And this.
And next circuit, yes. On the prayer of the learned advocate appearing for the petitioner, the matter stands adjourned. You are there in that matter, 16th. আচ্ছা ওনার নাম দিয়ে দিও. Is the matter before the next available sir. আগেরটাও কি adjournment নিয়েছিল না? এটাতে 16টার ফাইলটা এইখানটা আছে. Yes.
I know 17.
Agitation under section 3032 G72 of Arthur Nine Samhita matter. My lord, a name taken by the co-accused, my lord co-accused standing on the same footing as in indulged on and from the Honorable High Court.
NDPS? No.
No.
Cattle smuggling.
Read with, we have not read the intersection. It will be read with section 11, Roman 1D of the Prevention of Cruelty to Animals Act.
He was neither present in the spot matter, nor he has any knowledge about the.
Charge sheet submitted.
Charge sheet pending.
Pending. Which co-accused granted?
Amal Mondal.
Follow.
Follow Mondal, yeah. That is Fakira, alias Fakira.
Similarly situated. You are Where is the complaint?
Page number 11, starting from page number 9.
Yes, Mr. Chakur.
Inspect that already there is a
Apprehending at his present applications present. Learned advocate appearing for the petitioner submits that an accused person similarly situated with the petitioner had already been granted anticipatory bail by a coordinate bench of this court on 27 November 2025. In view thereof, the petitioner may be granted anticipatory bail on any condition. Mr. Chakraborty with appearing for the state opposes the petitioner's prayer and draws our attention to several documents in the case diary and submits prima facie it appears that the extent of complicity of the petitioner hearing is similar to that of one Kamal Mondol who has already been granted anticipatory bail. In view thereof and considering the nature of accusations and the extent of complicity of the petitioner in the alleged offence, I am of the opinion that his custodial interrogation is not necessary. Allow 10,000 securities with more so when Mr. Chakraborty opposes the petitioner if he further submits that investigation is not yet complete. Allowed 482 at এই condition গুলো দিয়ে দেবো এই similar দিয়ে দিবি ওই যা যা clause আছে yes 18 no one appears on behalf of the petitioner and no accommodation has been sought for, though Mr. Bhattacharya and the advocate appearing for the state is present. Stop as a last chance, huh? As a last chance, comma, the matter stands adjourned. Please the matter for further consideration before the next available circumstance.
Number 19.
Next, then go to next circuit. Then go to next circuit. This was on the earlier occasion also you took adjourn. Yes, what do you want? Tell us.
Accepted.
An adjournment has been prayed for on behalf of the petitioner, though the learned advocate appearing for the state respondent is present. In view thereof, as a last chance, in view thereof, is the matter before the next available circumstance. Yes.
Number 20.
Next circuit. The petitioner submits that service of prays for an accommodation as service upon the victim is not complete. In view thereof is the matter before the next evidence. ওনার নাম দিয়ে দিও স্টেটে
number 21. 21 and for the petition. This allegation matter, 329 of the deed, 321 to 328, to be matter, DNS matter, this is matter only allegation is trespassing and matter criminal conspiracy matter. Allegation is that they are trying to grab the land matter, but his name is mentioned in FIR matter last portion. They mentioned matter some organized crime syndicate member.
Where?
Matter page number 10 matter. First portion FIR matter there.
Just a moment. This is page 9 is the FIR.
Matter. They matter page 9 mentioned firstly 3 persons name matter. The Orange Burman, Ujjwal Bhadubi and Madam Dolly Ghosh.
Where are you reading? Then let me see. Horen, Ujjwal and Dolly. Me too. Joined hands to grab my land. Very good then. Lodged a complaint. Thereafter,
This is my allegation and my already title suit pending for the planet court.
what is the allegation against you?
My on the next page, page number 3, my the allegation that some organized crime syndicate members so and so my lord, they try to grab that and this person. So this is the only allegation, my lord.
Your name is?
My name is my lord Papun Sen, my lord, and 6. My lord.
6. Charge sheet submitted.
Was statement of the witnesses also.
Specific.
Earlier there is an injunction that prevent him resting from enter into the land. They try to enter into the land.
There is a allegations, any specific allegation?
160 statement of it.
Petitioners, my lord.
Charge sheet submitted.
That's it.
Last page is to be seen.
That's it not submitted, my lord. And my lord, another court was to already entered on bail, my lord.
What is your name you said? What is your name you said?
Shopon Sen. All are club members, my lord. They intentionally, my lord, put their name.
Shopon Sheikh.
Shopon Sen. All my lord, section is my lord, under magistrate power.
Apprehending at his present application. Leading State Assistant Learned Advocate appealing for the petitioner submits that the dispute has a civil profile. Inasmuch as a title suit is pending between the parties. The petitioner has been falsely implicated, though no specific overt act, and that no specific overt act has been attributed to the petitioner. In the said conspicuous, the petitioner may be granted anticipation. Minister and the advocate appearing for the state has opposes the petitioner's prayer and submits that the investigation is still continuing, and there are incriminating materials on record against the petitioner in support materials on record against the petitioner. Having heard the learned advocates, ওইটাতে লিখবেন ওই first paragraph, who accused person similarly situated with the petitioner had been granted anticipatory bail. Having heard the learned advocates appealing for the respective parties and considering the materials on record, including the statements of the witnesses, the nature of acquisitions, the nature of acquisitions and the extent of complicity of the petitioner in the alleged offence. I am custodial interrogation of the petitioner. His custodial interrogation is not necessary. However, his movement needs to be restricted. Allow 10,000 to share rupees on local food with the further condition that the petitioner shall meet with the investigating officer once a week till completion of investigation.
Deputy Officer.
দেখে নাও তাও তো ভুল হয় আমাকেই কারেক্ট করতে হবে পেন ড্রাইভে দিয়ে দাও বাবা আমি দেখে একেবারে মিলবে
Item number 22.
On the last petition, there was hard and state was asked to produce the report whether there is any injury on. The cases of under section 85 and 88 and 109 of same option up in the white book. Worship,
85 murder.
worship corresponding to 88A.
Who are you?
The factor complainant stayed away with another person, and on that regard, I had lost a missing diary for the local case, and here is the missing diary. I did not know as she was missing, so that I lost the missing diary. And thereafter, the person with whom the de facto complainant stayed, that person's wife also lodged a complaint against the de facto complainant.
What is the allegation against you?
The allegation is against me that I inflicted torture along with my family members upon the wife.
And what about your family members? They have got. So why you are not going for bail? Charge sheet submitted?
No, my lord.
Charge sheet not yet submitted?
No, my lord.
She fled away. She was not residing with me. I have the copy of the general diary of missing diary lordship.
A copy.
Missing diary, missing diary is of 15th of October. And the FIR lodged on 3rd of November.
How can it be 3rd November? Because she fled away on 11th October.
She fled away 11th of October.
Just wait, what you have written. Yes, yes, madam.
Yes, my lord.
What is the
This is
injury?
the
Complainant. This is complainant.
no, my lord. This is the statement of the doctor. There was no injury report, lordship.
Just.
But the victim lady is pregnant, my lord, and the expected date is 7th March 2026. And my lord, this is very astonishing. In this condition, my lord, how could she
Lodge the complaint.
no, how could she run away with another person's husband? Yes, she was already pregnant, my lord.
We have heard you. Then if there is no injury, then the basic ingredient goes. Ashok, apprehending as presented. Such learned advocate appearing for the petitioner submits that the petitioner has been falsely implicated. Stop. On the rudiments of submits that petition submits that on the rudiments of unfounded allegations, the petitioner has been falsely implicated. Stop. The de facto complainant went missing on and from
11th of October.
11th October 2025, and a missing diary to that effect was lodged by the petitioner on
15th of October.
15th of October 2025. Alleging that she was having an extramarital relationship.
Yes, they are after the field.
Alleging such as in the said conspectum. Thereafter, when it was due.
Wait, Lakshmi, I have added another complaint was lodged by the person, the wife of the person, wife of the that
Further submits that
stayed away. That is page number
one
8.
Unju Bormon, who happens to be the wife of. Where have you said that complaint have you annexed?
Yes, Lakshmi, at page number 8.
Unju Begum, now who is the person with whom the lady has?
Unju Begum says.
Who is that? On the basis of false. And as such, the acquisitions made are not sustainable. In the said conspectus, custodial interrogation of the petitioner may not be necessary. Mr. as a learned advocate appearing for the state opposes the petitioner's prayer and draws the attention of this court to several documents. This is not in the case diary, madam.
No.
The case diary. How did it not go into the case diary? How it was not included in the case diary?
So there was no injury report. Later, the direction was passed upon the state for production of injury.
Opposes the attention to the statement made by the witnesses and the later dated 19 December 2025 of the doctor who attended the de facto complainant. Having heard the learned advocates, considering the materials on record, the doctor's certificate, the nature of acquisitions, and the extent of complicity of the petitioner in the alleged offence, I am of the opinion that his custodial interrogation is not necessary. However, his movement needs to be restricted. Since investigation is not yet complete, allow 10,000 to be further with the further direction that the petitioner shall meet with the investigating officer of the case once a week till the investigation is complete.
Number 23. The application of number section of 109, 117 subsection 2, 118 subsection 2, 126 subsection 2, 303 subsection 2, 3 files of the article there should be. Allegation is that brother of the de facto complainant, he was riding in his motorcycle at that time. 4 accused persons, including these 2 petitioners, they assaulted the victim, as a result of which we sustained serious injuries. My instruction is that while riding motorcycle, we made an accident for that reason. 2 of the co-accused persons, they are already on bail also.
Investigation complete. Two, then why didn't you did not apply for bail? Where is that order? It's 6. You are Ajibul and Habibul. Ajijul and Habibul. Yes, Mr. Chakraborty.
There are several 161 statements. Out of that, one eyewitness, 161 is there, number 1. Second, the weapon that were used was metal rod and steel. And they note the consequence that with metal rod, if somebody is hit on the head, there is only possibility to die. So the intention was very clear, my lord. There was an attempt. My lord, the sections are there, and not only that, the injuries were severe.
Injury?
Severe injuries. Both the injuries, page number 37 and 50 are folded. Serious allegations, my lord.
Apprehending arrest. The injury report is there. Who are obtained? Who have been granted bail?
That's a regular bill. They were arrested and given one Nazibul Rahman and Saiful Muhammad alias Ram.
All on same.
Apprehending such and such Mr. Banerjee learned advocate appearing for the petitioners submits that no specific overt act has been attributed to the petitioners, and similarly situated co-accused persons have already been granted bail. Investigation is continuing, na? There is has already been stop. The incident occurred. The incident no specific overt act has been attributed to the petitioners. Situated person in the said conspectus, they may be enlarged, they may be granted anticipatory bail. Mr. Chakraborty has drawn the attention, and the advocate has drawn the attention of this court to the statement of the witnesses, including the injury report. Having heard the learned advocates and considering the materials on record, including the statement of the witnesses and the injury report, the nature of acquisitions and the extent of complicity of the petitioners in the arrest offense, I am not inclined to exercise discretion in their favor, more so when upon completion of investigation, more so when Investigation is still continuing. Dismissed.
Number 24, order done for the petition of 21 himself.
Why?
Some instructions are required from him.
আগেও কি একজন করেছে তাও? নতুন last occasion also you do that, German. What are the sections? What are the sections, sir?
Under section 329, subsection 464.
Husband is here. Husband is here.
Oh, my lord, this 376 is.
Oh. That's why you do not want to do. Then why did you take time? You could have told us on that date itself that I want time after vacation. No, this becomes forum shopping, sir. If the first day you have said,
Statement of the
who is your leader? Who is your leader? Pardon?
Not like that.
This is not proper, sir. You could have told that I will not get the instruction, you take it in the next bit. This becomes a forum shopping.
It is very specific allegation.
An adjournment has been prayed for on behalf of the petitioner. Though the learned advocate appearing for the state is present. Stop as the last chance, comma. The matter stands adjourned. Please the matter for further consideration to the next available circuit dates.
Number 25.
Arrested already? On the prayer of the learned advocate appearing for the petitioner. Petitioner? The application for anticipatory bail being such and such is dismissed as not pressed.
26, my appeal.
যে তিনটে ম্যাটার ওই টিচার যেটা মনে করে আমাদের ফাইল ওটা কারেকশন যেটা একদম উপরে ফেলে
Charges under section 126 subclause 2, 115 subclause 2, 324 subclause 2, 118 1 subclause 118 subclause 1, 109 subclause 1. There is an attempt to murder, grievous hurt, common intention. Yes, there is a 3 person has been implicated, and kindly see the injury. There is the injury, but kindly see the who assaulted. The 3 person has been implicated, and there is a allegation regarding the money.
investigation continuing.
Yes,
Defect.
My lord,
and
if your lordship kindly have a look at page 29, this is the injury report. So the nature of injury is simple, but head injury is there, sharp cutting injury is there. 161 statement of the victim is there, my lord, at page 7. I have already folded it.
Petitioner is the Onukul Borno.
অনুকূল
Onukul Borno. And another one is Palash Bormon, Dinesh Bormon.
All are FM.
Yes.
Any recovery? Short cutting weapon?
No, my lord.
So injuries
Extending from right to left.
So far, my instruction Palash
Pleading.
Bormon is assaulted, he is arrested, he is in custody, and Dinesh Bormon got anticipatory bail, my lord.
Dinesh Burman name is not. Dinesh Burman's name is no allegation is against you. Any the injured witness's statement is there?
Yes, my lord.
Which one?
At page. No, mother of the victim is there.
That is page 7.
Yes, my lord.
No, the victim's statement is not there.
No, my lord.
Why? Are you sure, Mr. Tajid?
Yes. Can I get
No,
I'm sure. But
Victim का चीज हमने
mother of the victim. No.
Yes.
Mother and neighbor of the
Appearing and Mr.
Statement 161.
Appearing for the petitioner's office. The petitioner has been falsely implicated. No specific overt act has been attributed to the petitioner. Who accused person similarly situated had already been granted. No, sorry. In the said conspirators, petitioner's custodial interrogation may not be necessary. You are defective. What you are saying?
There is who injured the victim by sharp thumb.
Mr. Bhattacharya
On his throat, that is on the vital part of the body.
state opposes the petitioner's prayer and draws the attention of this to the statements of the witnesses as well as the injury reporter. Mr. Sajan Sir, who enters appearance on behalf of the de facto complainant also opposes the petitioner's prayer. Having heard the learned advocates and considering the statements of the witnesses, the injury report, the nature of acquisitions and the extent of complicity of the petitioner in the alleged offence, I am not inclined to exercise discretion in his favor, more so when investigation is still continuing. Dismissed. Yes, next.
I'm going to go.
Number 27. Apathetic. One 26 surplus to 118 surplus 118 surplus to 109. or
Same,
surplus one.
same.
Sir, can you see the injury below?
No.
There is a dispute regarding both the family members, both are the neighbor, no? Family dispute.
Cut injury with knee fellowship. Two victims are there, a de facto complaint and his son. A charge sheet pending, and one eyewitness is there. Specifically stated the petitioner name, page 11.
Whether the injury is simple and serious.
That is not mentioned in the injury report. And one OPD ticket is there, where mentioned injury by knee and fist cut injury.
Where
over-
is the statement of the witness?
Yes, page 11, Shajol Rai.
Petitioner is?
Vishnu, Vishwajit Mullik alias Vishnu Mullik.
The injured witness is here.
Yeah, no, he's the eyewitness. Victim statement not recorded because charge sheet is pending. The neighbor and eyewitness. Shajol Rai. OPD ticket is there, Lordship. Stages given.
That is which page?
3 and 3-5.
$35.
3. Page 3. Only 3.
সেম আগেরটার মতনই হয়ে যাবে ডিনার Mr. Bit appearing for the petitioner submits that there was a previous dispute between the parties, and as a consequence thereof the petitioner hearing has been falsely implicated. No specific overt act has been attributed to the petitioner, and as such his custodial interrogation may not be necessary. The Honorable State opposes the petitioner's plea and draws the attention of this court to the statement of witnesses and the injury report. Having heard the learned advocates and considering the statement of the witnesses, the injury report, the nature of accusations and the extent of complicity of the petitioner in the arrest warrants, I am not inclined to exercise discretion in favor of the petitioner, more so when investigation is still continuing.
Great flush.
This is number 28. But I'll go.
Lordship, in this matter, Mr. Kolol Ataji is there, Lordship. He is busy in court number 3, paying for 1 day. Kolol Ataji.
CD you have got?
No, Lordship, I have no CD.
Not today.
Now 29.
Only the business is paying for Passover.
Why? He's not here. He was here. What he is doing there?
Not today.
Not today.
Now 30.
But I have got the pity.
No copy, sir.
Without service of the file is.
Why, sir? You are not doing the matters. Why? I don't.
But nothing has been recovered from my possession. Malad.
Yes, madam.
Charge sheet submitted. I am not verified named accused and.
Somebody do it. So he was here just now.
See the copy of the brief yet, madam. That is the problem.
When did you start?
But wrong back, but without service, but but from whom recovery was made, they are granted bail by the law.
When they pray for adjournment, you people oppose. And now they are there, you are again praying for adjournment. OAQ statement.
Yes, OAQ statement even from whom recovery was made, they granted bail by this Honorable High Court. Right?
Now,
The CD is not mentioned. I am not the FIR named accused. Charge sheet submitted. I have annexed the charge sheet. 21 kilo gaja has been recovered from 3 persons. They have been granted bail by the Honorable High Court. I have annexed the charge sheet. I am not the FIR named accused. My name has been transferred in the charge sheet. And this is the FIR. Everything I have annexed.
This is bail, not anticipatory.
But from whom this recovery was made? 21 kilo gaja has been recovered from 3 persons. They have been granted bail.
Yes, but your name, how can we know that this OAQ statement?
My lord, I am not the FIR named accused.
But still, we have to
Charge
see
sheet,
the
charge sheet, yes.
Not today. No. Unless you bring the CD, then we are going to allow the. এটা ওনাকে ফেরত দিয়ে দাও, এই অর্ডারের কপিটা দিয়ে দাও। No, why the PPs are not here? I don't understand. Where are they? Both of them are engaged. Both of her are here.
Yes.
Huh? Aditi Chakraborty.
No, why did out of state?
Then the APP must be having his juniors. Who are his juniors?
Fortunately, in this case, engaging assistant.
To call him, where is Mr. Arjun Chaudhary? Where is he? Yes, what is the case about? Punta Doctor.
31.
ভাস্কর দাস নতুন হয়ে গেছে
কোনটা যেমন ডাকছো? Sir, where are you?
I was on my legs before.
You must be having some juniors.
Milord, my juniors were there. Milord, I have been told 30. Milord, it shows. Milord, it has been assigned to me. But Milord, the brief is not with me. Milord, some miscommunication happened. Milord, I'll check with the office. But kindly make it not today. Milord, by tomorrow.
Not today.
I'm grateful.
I think 31.
Now who is opposing him?
31.
My lord, praying for not today. Mr. Niloy Chakraborty's matter.
Where is he? The CD must be with him.
No, he is in court number 3.
Then where is the CD? Where is the CD? CD has not come? Then let us call that investigating officer. Who is this? He has not sent the copy.
Must be maybe with Mr. Niloy Chakraborty.
So Niloy Chakraborty doesn't have any junior.
Bhaskar Das is a junior.
Where are you, sir?
No, my lord, I wasn't.
Yes, do you have CD of this matter?
No.
31?
No, my lord, CD is not produced.
Why? Then ask your officer to come here before this court why CD is not being brought.
CD is not. I have the instruction.
Whose instruction?
To
When did you receive the brief?
Section 1512.
The 15-12, we are today on 22nd.
Yes.
Which police station?
There is
Dinhata.
Dinhata.
20th November.
Yes, Mr. Chakraborty, where are you? Your juniors also cannot assist.
I was in court number 3. One day notice tomorrow.
If you are not there, see that somebody else is there with you. Repeated adjournments are being taken.
There is no CD, my lord. I have a list.
Will you get it tomorrow?
My lord, definitely. এটা কালকে একদম সকালবেলা নিয়েছি।
Not today. Yes, which one you are doing? Item?
Well, that was 31, oh, 30.
30 was
Not today. 32 minute claim.
32. Who is there?
I know 32. What about it? But allegation under section 341, 323, 431, and 34 of the Indian Penal Code. But allegation is that, the informant is an housewife by occupation on 22nd of July 2010. A call picked up with the accused person over the issue of some trees, which planted by the informant or the land of the Gopi Bishas. Subsequently, so 6 years ago, land was
Yes, madam. What is the injury report?
Yes, sir. This is the injury report, my lord. Page 18.
This is a investigation is continuing.
Yes, madam, this is a case of 2010, my lord.
10.
Yes, my lord.
What are
Kindly
you doing, sir?
consider his conduct, ma'am.
I should have printing as the presenter. Well, these are at the bottom portion of your bag or what? You do not bring it out and read. The present applicant, Mr. Mohol, and the advocate appearing for the petitioner submits that
yes, sir.
the petitioner
Can
has
I
been
withdraw this certificate?
in 2010 matter. So apprehending as present Mr. Mohol and the advocate appearing for the petitioner submits that the petitioner has been falsely implicated. No specific overt act has been attributed to the petitioner. In the said conspectus, the petitioner may be granted anticipatory bail. Mr. And the advocate appearing for the state opposes the petitioner and substance that the instant cases of the year 2010 and the petitioner is and investigation is also going.
Yes, my lord. That sheet has
That's
been
a
submitted
certificate.
long
All
back.
other this person granted and bail, only this person is left.
So go and obtain bail on the prayer of and advocate appearing for the petitioner. The application is dismissed as not pressed. Unar naam diye proceed.
CT tab.
Number 33.
Adjournment হয়েছিল নাকি? Not today, কি বলতে পারবো? Thirty-three. এই তো সুভাষিস মিশ্র, he was just now here. You are there in respondent, you are there, 33. 33, 34, all are of Subhashish Mishra. The fighter of 33. Yes. There was no recovery, Mr. Bhattacharjee. Followed? Yes, recovery from you.
No, madam. Lord, kindly have a look on the seizure list, my lord. Page 12.
From the house of Hamidul Haq.
Hamidul Haq seized from, my lord, the column 4. Nurbanu Bibi.
It is below commercial.
My lord, I am coming to that aspect, my lord, the quantum of, my lord, two, my lord, type of contraband, my lord. 99 grams of Yava tablet and, my lord, 500 grams of Escap cough syrup.
So that crosses the contraband commercial.
My lord, with regard to, my lord, cough syrup, my lord, 1 kg is commercial quantity. My lord, here alleging 500 grams.
Yes, you're there. Is it commercial quantity?
But I have to check out actually code number 3 consecutive matter work at 2 p.m. Just now completed the matters. Just 1 kilo commercial. 1 kilo commercial.
Codeine, 1 kilo is the commercial.
Codeine phosphate, my lord, 1 kilo is the commercial quantity. The alleged recovery is 500 gram. 500 gram.
Together with Yava tablets, na?
Yava tablet 50 gram is the commercial. 50 gram. 50 gram is the commercial. There are two types of
So total comes to how much? Total in that case.
Total is not the.
Now is his name in the seized from him? You don't have the chart CD.
Yes, right. It is there, my lord.
You have not checked it up. You have not checked it up.
I have checked, my lord. Right now, I. Just 2 minutes possible. No, tomorrow.
He is there
to submission.
Next matter. You are there. Next matter. You are there.
Yes, ma'am. Yes, ma'am. I am there. Lord, I have been instructed by my client, my lord, to not place this application.
On the prayer of the learned, don't see it, he is not on the prayer of the learned advocate appearing for the petitioner. The application.
No, 32, I have got the
dismissed as not.
32, I have got it.
32, he does not pressing.
Oh.
Dismissed as not pressed.
33, I have got it. I have received
34, not pressed. 33.
33, I am just now I received the case.
What happened? You do not want to do it. 33.
119 grams of Yava tablet and 5 bottles of codeine phosphate. That means 100 ml each. That means 500 ml. The codeine phosphate. That is not commercial quantity. That is not commercial quantity. But The 119 grams of Yava tablet, that is commercial quantity, 50 gram is the commercial quantity.
Recovery from him.
No, my lord. Recovery from, my lord, 14.
Nurbanu Bibi.
14. My lord, from Hamidul Haq. From one Hamidul Haq.
But Caesar list
From the
shows
house of.
no, number 4 seized from Nurbana Bibi.
Seized from
Nurbanu Bibi.
Nurbanu Bibi, wife of Endadul Haq.
Oh, Hamidul Haq, yes. From your house it was intercepted.
Yes, madam. As per Caesar list, from the house of this petitioner.
Page 12, you have an
Page 12, madam. Page 12.
You are Hamidul.
That reflects that, my lord, the place of Caesar was Hamidul, but from whom, my lord, allegedly recovered, that is
your house it is
Lord,
taken.
kindly come to, my lord, I have some.
You have some
Page 10, my lord, of the FIR. Page 10.
Charge sheet submitted.
Charge sheet, my lord. My lord. My lord, charge sheet submitted. Submitted. On 15/10/2025. 15/10/2025. My lord, page 10, my lord. Few, my lord, discrepancies, my lord. I would like to, my lord, point out, my lord, kindly appreciate it. Page 10, my lord.
Yes.
My lord, the paragraph starts with, my lord, upon entering the premises at 13:05 hours, we observed Hamidul Haq alongside his sister-in-law Nurbanu Bibi and Rabbani Haq in the act of attempting to sell contraband article to an unknown individual. The illicit item were stored in a plastic bucket, plainly visible on the floor. At the sight of the police party, the two male accused bolted across the adjacent cultivated marshal. We managed to detain Hamidul Haq briefly, but the others escaped. My lord, the third line, my lord, that, my lord, in the act of attempting to sell contraband article to an unknown individual. My lord, no individual, my lord, no name has been extracted.
Sale to an unknown individual.
Unknown individual, he was
It was
present.
with you.
My lord, no name has been extracted from the, my lord, the arrestee.
How does that help you, Mr. Mishra?
My lord, the defective investigation, my lord, the shabby investigation.
They have
been arrested, my lord, who were present there. My lord, as soon as, my lord, the police entered into the spot, my lord, the unknown individual, my lord, flew away. They arrested, my lord, 3 persons.
So then how can the entire incident be disbelieved at this?
My lord, I am coming to, my lord, the next aspect.
Yes.
My lord, the kindly appreciate, my lord, from whom, my lord, the seizure was made. The seizure was made, my lord, from Nurbanu Bibi. The illicit contraband article, my lord, was possessing by this particular lady, my lord. She was in, my lord, the exclusive possession of that contraband article. With regard to, and my lord, with regard to, my lord, the so far, my lord, the quantum of, my lord, contraband article is concerned, my lord.
But why didn't you,
14
Mr.
phosphate
Why,
happens to be, my lord, below
why did
commercial, my lord.
why?
Lord.
Sir, how can that be? The Java tablet causes the commercial.
Yes.
So the lot has to be constituted as a commercial.
Yes, my lord. The two part of contraband article. One is, my lord, methamphetamine, that is Java tablet.
That is within the below commercial.
No, my lord.
But that is
Methamphetamine above commercial. Cup syrup. Odin, my lord, below commercial.
Now what have this Nurbanu was arrested?
Nurbanu was arrested, my lord.
Nurbanu was
In
arrested.
FIR, it's also stated that the Nurbanu is the sister-in-law of the Hamidul. Written in the FIR, my lord.
Then when Hamidul was in the spot, your statement is why didn't you detain Hamidul? Yes, you detained Hamidul.
Yes, my lord.
So the person to whom water was being sold has fled.
Yes. My lord, is there any, my lord, plot information but where the house was situated? my lord, with regard to that, nothing has been, my lord, stated in the FIR, but where the house is, my lord, situated. My lord, so far, my lord, the Hamidul is concerned, my lord, as because, my lord, from where, my lord, the contraband article was seized, it is from allegedly Hamidul's house. My lord, is there any, my lord, narratives with regard to the FIR, my lord, that, my lord, that house is situated on such and such plot, such and such Kotian? Nothing, my lord. And my lord, one
That
very
is a matter
indispensable
of
aspect.
trial, Mr. Mishro. That is a matter of trial, not here.
My lord, prima facie, it does not, my lord, implicate me, my lord, kindly consider, my
Your
lord.
name features.
My lord,
Your name features there.
my lord, that is, my lord, that Nurman who was arrested, my lord, from her statement, my lord, my name has been, my lord, extracted.
No, Hamidul, you are Hamidul.
My lord, I
Hamidul
am.
was present at the spot.
No. Hamidul was not present.
My lord, kindly appreciate,
Hamidul
my
was
lord.
not present.
Hamidul
The seizure
along
was
with
made from the house of this Hamidul.
But you are, upon entering the place, we observed Hamidul alongside his sister-in-law Nurban and Rabbani.
My lord, kindly appreciate, my lord, who are the arrested persons. That is page 11, my lord. Page 11.
হ্যাঁ তো হামিদুল কাছ থেকে সিজ হয়নি তো হামিদুল তো নাই পেয়ে যাবে তো
Is it there? How have you come to the house of Hamidul? What material you have?
It's a very indispensable aspect, my lord. I'm coming.
And is there any antecedent about this
No.
person?
Regarding antecedent, there is no reflection in the memo of evidence, my lord. Antecedent is
Now, how
not
did you identify the house? Take it up and come tomorrow.
my lord.
Yes, next one.
Number 35.
আয়োকে ফোন কর
35. Yes.
Your lordship, kindly fix the matter for.
I am for the state, your lordship.
Your lordship, kindly fix the matter.
This
for
was
next-
yesterday also at John.
Uh,
Why you are not doing?
Actually, your lordship, the learned advocate for this matter, she had to leave the premises for a personal emergency.
She was just now here.
Yes, sir. Yes, your lordship. After that, she had to leave for a personal emergency. It was unavoidable.
Not.
Grateful, your lordship.
Grateful, your lordship. Item 36.
আগের দিন no one appears on behalf of the petitioner and no accommodation has been sought for. You are appearing?
Yes.
Though the learned advocate appearing for the state is present, stop as a last chance, the matter stands adjourned. Release the matter before the next available certificate.
No, 37. 37 Khan is not competent with that.
Mr. Poddar, learned advocate appearing for the petitioner submits that the service upon the victim is not complete. In view thereof, is the matter before the next available certificate. Yes, next.
38.
Who is 38? What is the matter about? NDPS?
No recovery. We are not named in the FIR, charge sheet, first charge sheet, my name not transferred. After last supplementary charge sheet, my name transferred. From the statement of cause, my implication on the basis of statement of cause.
You have the Caesar list here.
From the FIR also,
Charge sheet submitted.
charge sheet submitted, subject that.
Can it be tomorrow, my lord?
Check it up, sir. If
Not
it
to
is-
abstain, my junior. Just pass over.
No, if it is co-accused statement and no recovery from you,
Principal also granted, that is honorable court, case 17.
where is it? You don't have the file.
Just I send my junior to check.
আচ্ছা পাসওয়ার্ড এই পাসওয়ার্ড করে রাখ
And number 39.
39, I have not received the case diary. It's
Next
of
circuit.
Tufanganj police station. Tufanganj.
what that is also NDPS
Below commercial farm.
yes Mr. Achal
Not today, madam. Just not today. We'll
Not
try to
today.
collect the case diary.
And number 40.
The item 40 is to appear on the only of those.
This is a matter.
you're there
The office he has left.
Comes from Shiliguri. I thought he left early.
Lordship, this matter, there was offense, an FIR was registered against there are 4 accused. 4 accused, and the offense, the sections, allegations were under section 108 and 61(2) of the BNS. That is attempt to, abetment to suicide and criminal conspiracy. Now, Lordship, the principal accused, the wife of the victim, has already been granted bail by the learned vacation judge Shiliguri.
wife of the victim
Wife of the victim, the husband, he has committed suicide. There was some marital acrimony between them. Due to continuous marital acrimony, he committed suicide. Thereafter, the principal accused, that is the wife, she was arrested, and then thereafter she was granted bail by the learned vacation judge. The same learned vacation judge also rejected this anticipatory bail application by these 4 accused. Now, these 4 accused,
where is that order
Lordship,
that order
it's in Lordship in
you have
Annexure C. Yes, I have annex. It's in Annexure C, page number 16, Lordship. The order of rejection and the order of bail of the principal
just a
accused.
moment
Galaxy side.
so the lady is in custody was
No,
in
that
custody
she was granted bail.
She has
She was
been
in
granted
custody, and then thereafter she was granted bail.
Vacation judge, vacation
Vacation judge, the learned vacation judge Shiliguri.
very good then what happened
Then what has happened? These the anticipatory bail of these 4 petitioners were rejected by the same vacation judge, challenging which I am before this honorable court. Now, Lordship, if I may,
where is that order of rejection that
order
is
of
not
rejection
yet-
is page number 16, Lordship, Annexure C, criminal miss case number 31. No, Lordship, it's page number 10, criminal Annexure A, criminal miss case number 14 of 25. I'm sorry.
marriage how many years
Lordship,
marriage
they got married in 2023.
23
23, that's what the FIR says. The victim husband got married with the lady.
now who are they Nepal Roy only they are
Lordship, the petitioners, they are the in-laws of the victim. In-laws of the victim, and Nepal Roy and Anita Roy, they are in-laws of the victim. That is the father and mother of the principal accused. And Binota Roy and Hiren Roy, they are relatives, some far relatives of the
charge sheet submitted.
Charge sheet has not been submitted. Now, this is where my contention comes in, Lordship. Lordship, none of them has any other criminal antecedents. Moreover, they are in no way connected with the offense. Why do I say so?
the petitioner, sorry, the principal accused and the deceased victim, they used to stay separately in a rental accommodation. And moreover, as there was marital acrimony, there was some marital dispute between them. The deceased, he left his wife at the rental accommodation and came to his own parental home. At his own parental home, therein he committed the suicide. Now, why is this important? Lordship, in this regard, I would like to rely on a Supreme Court judgment passed by, in the case of Prakash v. State of Maharashtra, 2024.
Very good. What is the fact? Tell
Yeah,
us.
the fact is, Lordship, and this is also a case of 306. 306 abetment to suicide. However, in this case, the allegation was against the husband that he abetted the suicide of the wife. In this case, what has happened? The Supreme Court has quashed the proceedings and has discharged the accused husband and the other relatives.
Question of trial, sir.
That is a question of trial, but no, Lordship, the reason why I'm saying this kindly comes to
So let us see what is the involvement. Why your name has featured in your names are there in the
The names
complaint.
are there, Lordship.
Show us what is the allegation against you.
Lordship, yes, the allegation, the FIR, Lordship, yes.
They were residing at a separate rented house.
Rental house, right, Lordship.
Where is that story?
Assisted Lordship with one document.
No,
Yeah,
that is what the
just show us what is the
Yes,
allegation against you with the complaint.
Lordship, in the first Lordship, in the 1, 2, 3, 4, 5, 6, in the last 6th line of the page number 12, that is in the first page of the original complaint. বিবাহের কিছুদিন পর থেকে দীপিকা রায়, যিনি আমার পুত্রবধূর আমার ছেলের সাথে আচরণে ঝামেলা ঝগড়া শুরু করত এবং আমি আমার বাড়ির সদস্যদের
Or let me hear him. What is the allegation? Yes, what is the allegation against?
I have given the time declaration in the last side note. That is elaborate and that is the, I think, best evidence possible. At the bottom, he writes something to his father. It's a very emotional letter, last letter.
So does their name feature?
Feature, but I believe something more is required to bring home a charge under section 306. But at this stage, I am opposing it.
All right, keep it tomorrow. I shall go in quick.
Great Lordship.
Not today.
CD will remain the.
No, you give it tomorrow when I take it up. You give this. So see it a ফেরত দিয়ে দাও. Can you give a? Oh, this is the only. This is original.
Apart from this, 161 statements are there.
All right, come tomorrow. I shall. So that password you.
She did not receive my letter tomorrow.
ওই সিডিটা ওনাকে দিয়ে দাও।
One mentioning,
Now.
Correction in the order,
Which one?
15-12.
দেখছো কিভাবে কারেকশনের সব আসছে, অর্ডারের ডেট দেখছো না কিংবা কিছু করছো না, সব এম্বারেসড আমাদের। What is the correction?
No, these two names have been mentioned in the order.
Pardon?
Two names were also required to be mentioned because the 3 person had filed this application of bail anticipation. But the Lord's right mentioned the name of one person only.
Because one person was.
No, in the application, there were 3 person application of yes. And other section, other such.
So why didn't you point it out?
No, when we had got the track code below, because they said that there is only one person.
How will you know that? Then what is the wrong with us?
No, actually, I had filed application for the 3 person in one application.
How do we come to know? Where is the application? Show the copy.
No, this mentions.
You are saying it is appearing before the trial court. Then maybe when you file the application.
There were
and-
3% Milord when we bring this application.
So why my usually?
I just clear it, Malad. Is it written and others is written, Malad?
No. It is only his one name.
One name, then there is a problem, because then
If others we understand, we could have included. But how this will be done? You check up your record.
That is all with the record in the court.
You don't have your petition.
I have come with the mentioning ethics.
Where is your petition? Show us that there were 3 persons.
I'll come tomorrow and tomorrow morning and after the celebration.
So why did I don't understand this? Usually does not have.
Yeah, last paragraph. No, there's no only petition. Then you are about.